How are you, my friend?
Simmons' fault? That's a good thing. That's true. Good afternoon. It's February the 28th, 2024, at a little after 1:30. Good. Thank you very much for the shush. This is the House Judiciary Committee, and we have a number of bills, but we're joined today by our speaker and several other important people. And then this guy on the left of the speaker, from my perspective, he's somebody else. So that's fine. So we're very happy to have the speaker here to testify on House Bill 810. Madam Speaker, if you'd like to begin, please.
Okay, I guess your other members will be just coming in soon. Okay, all right.
We all show up on time when you call us to the floor. For me, they just kind of roll in. It's terrible, really. Thank you, Madam Speaker.
Okay. Good afternoon, Chair Clippinger, Vice Chair Bartlett, and members of the Judiciary Committee. For the record, I'm Speaker Adrian Jones, and I'm here today with Baltimore County Executive Johnny Ochesky and Baltimore County Police Chief Robert McCullough to testify in support of House Bill 810, legislation to prohibit the use of a Glock switch or any other auto sear device in Maryland. These small devices, which convert legal semi-automatic firearms into fully automatic machine guns, make our communities more dangerous. As Chief McCullough will speak to in more detail, my county, Baltimore County, has seen an alarming rise in cases in which one or more firearms has had a Glock switch. And the mass shooting at Morgan State University last October involved a weapon with a Glock switch. The high volume of these devices in circulation and the fact that they can be produced by a 3D printer in someone's home make it very difficult to control their use. Despite a federal prohibition, law enforcement and prosecutors in Maryland believe this legislation is necessary to provide them with an additional tool to get Glock switches and other similar devices off our streets. At the end of the day, automatic weapons have no place in our community. House Bill 810 will continue our work to keep our neighborhoods safe and punish those putting citizens and police lives at risk. Thank you. And now I will turn it over to County Executive Ochesky and Chief McCullough for their testimony and to take any questions.
Thank you, Mr. Chairman. It's good to see you. It's good to be back in the People's House. I really appreciate the opportunity to be with you today. I want to thank all the members of the esteemed Judiciary Committee for your attention to this critical issue. I want to publicly thank and recognize Speaker Adrian Jones for introducing this critical legislation, as well as our Police Chief, Rob McCullough, for bringing this issue to our attention. We know that the safety of our communities is paramount, and as leaders, we are constantly looking for new ways to deter crime, save lives, and hold bad actors accountable. In particular, firearm safety has been a priority for our administration, which is why we were proud to pass the Bipartisan SAFE Act in Baltimore County that helps secure weapons and keep them out of the hands of those who wish to do us harm. I want to thank all the partners of the General Assembly and again, the Speaker for her leadership in helping to enact a statewide version of this critical legislation. Today, we're here to continue the work of keeping our community safe. We know that the only purpose of a Glock switch is to effectively transform a legal firearm into an illegal machine gun, enabling someone to fire more than 30 rounds in 2 seconds and potentially injure or kill far more people at once. House Bill 810 is about taking these would-be machine guns off our streets and holding anyone who would even attempt to use these illegal weapons accountable. As MACO president, I've had countless opportunities to speak with my fellow leaders about our shared challenges. It's clear that this is a danger and a concern statewide. We know that our officers, as Chief McCullough will inform you, have reported finding Glock switches at crime scenes while executing search warrants. demonstrating that this is a true and ever-present threat in our backyards. However, our police departments and all police departments are currently unable to confiscate these switches and devices because Maryland does not reflect national law, which does and has for 37 years prohibited these switches. So House Bill 810 is a correction that lets our state law mirror national law, empowering state and local prosecutors to bring state criminal charges when these devices are not attached to a firearm, further enabling us to prevent these guns from being turned into illegal machine guns. So we humbly ask for a favorable report. And again, I thank and applaud the speaker for her leadership and for you and your partnership on this critical legislation. Thank you very much.
Mr. Chair and members of the Judiciary, I thank you for having us here today. And I thank the speaker for her leadership and for having us here today also. I'm Chief Robert McCullough of the Baltimore County Police Department. I'll briefly address the details of the bill, which are described more fully in my written testimony. Definition provided in the bill for a switch or auto sear device uses the definition from the Federal Criminal Code. The bill specifies that law enforcement can seize these devices in Maryland as contraband, the same as unlawful assault weapons. The bill adds a section that mirrors the existing prohibitions against bump stocks, which is the other device that can be used to make a firearm fully automatic. This new section makes it a crime under state law to transport a switch auto sear into Maryland and prohibits the manufacture, possession, sale, offer to sell, transfer, purchase, or receiving of a switch auto sear. Finally, the bill adds the use of a switch auto sear in the commission of a felony or a crime of violence to the list of offenses with heightened penalties. This list already includes the use of an assault weapon, a bump stock, or a high-capacity magazine. This important legislation will give us the ability to bring state criminal charges for having, making, or trafficking these devices, even if they are not attached to a firearm when we find them. I'll be pleased to answer the committee's questions about what we are experiencing in Baltimore County, and I urge a favorable report.
Thank you, Mr. Chairman. My name is Meg Ferguson. I'm a Senior Policy Advisor to the Chief of Police for the Baltimore County Police Department, and I direct the legal section. And I'm just here to assist the panel with any technical questions.
Members of the committee have questions they want to address related to the substance of the bill. The county executive and the police are here. You can direct those questions to them. Are there questions for this panel? Seeing none. Oh, wait, sorry. Delegate Pasteur has a question.
I would like to ask the panel if you can tell me who my favorite police chief is.
I would say that's not a fair question.
But who's your favorite county executive, delegate?
To me, who is my favorite county executive? Thank you, Mr. Chair.
Delegate Taylor, who is your favorite county executive? Delegate Taylor has another question. It's okay.
Yes, for the police chief, thank you guys for coming and bringing this bill, but you seem to have left open the opportunity for us to ask you. So how is it going in Baltimore County with the act that you've already enacted in the county?
I'm trying to follow your question. You say, how's things, you're saying?
You said we could come back to ask you how things are going in Baltimore County.
Oh, okay.
Yeah, how are things going in
to actually
Baltimore
meet with you
County?
guys, but things are going well in Baltimore County. Things are looking up.
This act actually is broadening an act or a program that you've enacted in Baltimore, right? Did I hear that correct?
No, that's the SAFE Act that you're talking about. That's something separate. So this is to address violent crime and the potential for violent crime. So this auto sear switch is something that we see people adding to, for example, a Glock handgun. And it converts that gun instantly from a semi-auto firearm to an automatic firearm. And of course, they add these high capacity magazines or extended magazines to a handgun, and it essentially a handgun becomes a machine gun.
Thank you.
Thank you so much for bringing this bill, Madam Speaker and her esteemed panelists. I have a question in terms of you're seizing the contraband and disposing of it, right? So will that seizure be able to be utilized for asset forfeiture funds?
You can or I can.
So these would just be seized and destroyed. They're already seized because they are illegal federally, but there's no ability to prosecute or to hold people accountable for them. But this is not something that would have monetary value that would be resold through the asset forfeiture.
That's a good thing. And so you just kind of break them up, throw them in the trash so people can't put them together and make ghost guns with them, right?
Right.
Perfect. Thank you. That's it. Thank you.
And if I may just add to this, just real quick, we not only these things manufacture metal, but we also see them created with 3D printers. So we often also see them in plastic form also.
Thank you, Mr. Chair. Thank you all for being here today. I just was looking at some of the oppo, and one of the oppositions just says that they wouldn't be opposed to the bill if you simply amended it to change the existing definition of machine gun to the federal definition. Is that something that you guys would be willing to consider? It should still include what you're looking for. It says under the federal definition, an auto sear is already defined. So is that something you would
Who was
consider?
asking that?
This is one of the opposition testimonies from Maryland shall issue.
So these devices on a federal level are already illegal. The problem is many times we seize them, and we can seize them in a large number and try to give them to our federal partners. And many times they won't pursue them as a charge.
Right. So this, if we took their amendment, it wouldn't shift that. You would still be able to do what you need to do. It would just change the definition in the bill to match the federal law. That's all it would do.
So I think the reason Madam Speaker introduced the bill in this form is that it treats these the same way as this legislature treated the bump stock. And that's why the provisions mirror each other. And the reason I think this legislature did the bump stock provision that way is because definitions to work in Maryland's framework for gun regulation, definitions are very important. So I think that the strongest way to pursue it is the way the Speaker's bill proposes to do it.
I think for the bump stocks, we did adopt language that was similar to the federal. I mean, that's also banned, I think, at the federal level. So, but I appreciate you. Thank you.
Seeing no further questions, we thank you all very much for
Thank
being
you
with
very
us.
much.
Thank you very
Thank you.
much, County Executive and Speaker and Police Chief for being with us. There are further people to testify, including Scott Schellenberger, Derek Leffler, Kathy Wallace, Sean Vincent. I'm not sure whether, do you have other people that you wanted to bring?
Yes, Officer Jedlowski,
Okay.
instead of Sean Vincent.
Yeah, it's fine. That's what I think I
And,
couldn't figure out what I was reading.
and these two are the people that you need to ask the detailed questions of.
Fine.
So-
So let's hear from you first then.
Yes.
All right, Mr. Schellenberger.
So good afternoon, Scott Schellenberger, State's Attorney in Baltimore County, here in support of HB 810. That would ban the switch auto shears. Obviously, you now know that the device can now turn a handgun into a machine gun. A few years ago, you outlawed bump stocks, and Delegate Erican, that's what we did. We tried to put it exactly mirroring the bump stock statute so that it would be mirror image. And so the best way to understand what these devices can do, Mr. Chairman, with your permission, can I play a 15-second audio?
Take a listen. Now you can hear what sounds like an automatic weapon there.
That is a shooting that took place in July of 2022 in Baltimore County. It was off of Compass Road in the Middle River area. A man and woman were in a car. They were shot. There were 20 bullets, which you just heard, 20 bullets in the vehicle that they were in. And therefore, this is definitely a problem everywhere, but including Baltimore County. And as already intimated, the shooting at Morgan State University that we all know so much about also had one of these devices that were being used. So what we're trying to do, obviously, is make this law illegal. I mean, this item illegal. So the feds have it. But honestly, the feds are so busy now that when we ask them to take cases like this, you know, particularly in the area of possession of the item, the feds don't have the resources to handle that. And so therefore, that's why we believe we need a statewide law so that I and every state's attorney's office in the state. Therefore, thank you so much. We need this for public safety. It used to be about fist fights, then it was about knives, then it was about guns, and now it's about automatic weapons, and we need to stop that.
Who'd like to go next?
I'll go.
Go
I'm
ahead.
Sergeant Wayne Jalowski, Baltimore County Police. I'm a supervisor over our firearms team for Baltimore County. Recently, we've been seeing an uptick in the Glock switches. Most recently, we did a search warrant in Baltimore County last week where a recovery of a handgun and a Glock switch was confiscated. And from an investigative standpoint for working gun cases in Baltimore County, we receive information a lot of times that people are selling, manufacturing these things with 3D printers and so forth. But because it's not really legal statewide and we can't get our federal partners to piggyback on like a smaller investigation because it didn't meet the federal criteria, they kind of just push it off to us because they're too busy, where we'll seize, you know, a 3D printed item and it takes us months and months and months to build a case with other criminal aspects to the case to go back in. And we recently did one that's pending trial in Baltimore County where we finally got in the door using the drug angle, but he had a 3D printer, was manufacturing 3D printed Glock switches and distributing out to people in Baltimore County. And if we had this law that just the mere possession of it, we could have got in the location much sooner and stopped it. And by not really kind of identifying what it is, as far as just contraband, and we can't enforce the federal level, it really, you know, ties our hands as far as being able to enforce the law with these switches. And we're also seeing a lot more of these things posted on social media with investigations. Guys are showing pictures of them. And then Baltimore County now just adopted the shot spotter. I know the city counterparts have them as well. And it, just like that video you just heard, we're hearing that weekly all throughout the county in Baltimore City where automatic weapons are used. And most of the weapons are being, it's the Glock switches put on the Glocks and converting them to machine guns.
Good afternoon. I'm here on behalf of Police Commissioner Worley from the Baltimore Police Department. As everyone's kind of highlighted, these devices are already illegal under federal law. The ATF has reported that the recovery of these switches has increased 570%. It's 570% between 2017 and 2021, and it's still on the rise. These weapons not only increase the danger to police officers, but they risk the lives of all our residents in Baltimore and throughout Maryland. As has been highlighted, these switches can be manufactured through 3D printers and just purchased off of the internet. As Madam Speaker mentioned, Morgan State is an example where we had this occur in our city, and we recovered these switches all the time. Since January of 2023, 62 guns that we've recovered have been had auto sear switches with them. So VPD believes that the passage of this bill will increase the public safety for all Maryland residents, and we request a favorable report.
Thank you, Mr. Chair. Thank you all very much for coming in for your compelling testimony. This is a priority for me, and I'm very excited to hopefully pass this legislation and thank all the supporters behind you for being here to help support this kind of action. The county executive mentioned that machine guns are illegal to use in the state of Maryland. Is that correct? I don't know. Should I refer to the?
If you can possess a machine gun, but you have to get a tax stamp through the ATF, and it's like a yearly thing you have to do, and it's a initial cost, and then you have to get the stamp updated each year.
And for all intents and purposes, if you attach one of these devices to a legal firearm, you are creating what is essentially a machine gun, which requires additional permitting and other types of things in order to make it legal. Is that correct?
Correct.
So by allowing these things to exist, we're putting in harm's way in theory, legal gun owners who are making their guns illegal. Is that but federally legal and now and hopefully state illegal? Is that correct?
There's no new machine guns that are being produced now. Everything it was post whatever, I forget the exact year. So then if you own one of the older machine guns, you have to get the federal mandated permits to hold them. This would not permit any legal handgun owner to possessing a handgun. It's just stopping a regular handgun to be switched at any minute to a full auto machine gun.
It's meant to happen. This bill is going to save lives, because what we're going to do is we're going to stop people from being able to mow a gun across as opposed to taking single shots. Is that basically what we're doing?
Absolutely.
Absolutely. Thank you all very much for being here.
Delegate Simmons, then Conway.
Thank you, Mr. Chair, and thank you, panel, for coming out, and appreciate the legislation as well. I just wanted to give you the opportunity to kind of draw down the significance of the impact of this device and how it's affecting the state of Maryland, not just in Baltimore, the Baltimore region, but throughout the state of Maryland. You talked about the numbers a little bit, the 570% and all that. I just wanted to give you a chance to expand on that conversation about the impact that you're seeing from a law enforcement stand.
Yeah, so anytime that you can convert a firearm so rapidly into an automatic weapon, it's a risk to anyone in the state of Maryland. If you can, within seconds, make that weapon different, you're gonna, whether you intend to use it or not, you're gonna put other lives at risk quicker, and it doesn't matter where that's happening in the state.
Thank you.
The chairman, thank you, panel, for coming in to testify. Am I correct? I understand that the cost of these units may be $20. Is that about correct?
Yes, sir.
And here's my problem. Once you activate the firearm to fully automatic, it won't stop until the clip is completely discharged. Is that correct?
That's correct.
So therefore, it's really a machine. Once you set it off, I mean, there's no stopping. It's out of control.
Right. It typically shoots about 30 rounds in 2 seconds, 2 to 3 seconds.
So you would have to discharge the whole 30 rounds.
Yes,
for
it will.
stop.
Yeah, it will empty the whole magazine until it's empty.
Thank you so very much.
Thank you, Mr. Chairman, and thank you for being here, distinguished panel. When an individual is caught with one of these altered firearms, are they charged with possession of an automatic weapon? And if so, how successful are we on prosecuting them?
See, the statute you passed a couple years ago actually uses the word machine gun. And although we can come here today and say they've converted it to be like a machine gun, when we would go into court, you would say it's a Glock and he had a device on it. So the fact that it's a regular handgun, I think, would not allow us to prosecute under the machine gun statute.
So you never prosecute, or you just,
No, we haven't. The only place we've been able to go with these is we have tried to go to the feds because it is illegal federally. But that's why we're here, because we're starting to see so many more of them. And now we're starting to see them in crimes.
So once you do prosecute, so with the avenues you have, how successful are you, and what type of incarceration do people receive for having these weapons?
Well, so House Bill 810 carries a minimum mandatory of 5 years and a maximum of 20. So if we get the bill, we would be able to prosecute and get a minimum of 5 years in jail.
Thank you very much.
All right, seeing no further questions. So, all right, Delegate Conaway.
Thank you, Mr.
I got you the
Chairman.
one time.
Another real quick one. So just to be clear, there is a mandatory minimum connected with this bill?
Yes, I think it's on page On page 5, 2I, for a first violation, the person shall, the word shall, be sentenced to imprisonment for not less than 5 years and not exceeding 20.
So that could be for just having the device, but not having it attached to a weapon if this passes, just for having the device?
That's the way I'm reading it.
Thank you so very much.
Let me follow up on that question. As I read this, and is it that there's an A and there's a B? So in B1, it says a person who uses an assault weapon, rapid fire trigger activator, a switch auto sear, and that's the relevant part here. If they use it, then it is connected to the existing mandatory minimum of 5 years. Is that, am I
You're
reading that
correct.
correct?
I stand corrected, yes.
So it is not mere possession.
It's
It would
the,
be using it that would be connected to a mandatory minimum. If they possess it, it would be a 3-year penalty, $5,000.
correct. I didn't read all the way down. Thank you.
Again, the people out there were the people. Okay, never mind. Are there other questions for this panel? Delegate Munoz.
So my follow-up question then is, I haven't seen what this device looks like. Obviously never used one. But I'm assuming it's not super threatening looking because you attach it to a firearm in some way, like in and of itself. I'm just concerned, is it possible there could be someone out there who has this in their possession because someone gave it to them to give to someone else and they don't even know what it is?
I haven't seen it. We deal with a lot. They've been trying to convert them into keychains. I know, like, they order them to China now. They're kind of advertising as keychains with the Glock switch on the bottom. Most people who are into guns, they know exactly what it does, and it serves one purpose, is just converting a firearm to be a machine gun. And it's about the size of a quarter. It's a very, very small little device, and it has a little usually toggle switch on the back of it that can either switch it to full auto or just regular.
Not to be too technical, but if you Google it, you can see pictures and you can actually scroll down and see a YouTube video on how to make it with a 3D printer. And that's all online.
But the mandatory for like a little device like this is if it's given to a child, if it's given to a young adult to transport or to hold on to for a friend or a family member, and they have no idea what it is, and we're giving them a mandatory 3-year.
The 3 years, the simple possession and the 3 years is not mandatory. It's only when it's on the gun.
Minimum.
And going back again to my question, the simple possession just carries a maximum penalty of 3 years. It's if they use it, there's a mandatory minimum attached.
Yes.
Yes.
Max of 3 if they possess. All right. Delegate Williams.
Thank you, Mr. Chair, and I guess it's just for Mr. Scheltenberger. So just to kind of go back on this mandatory minimum for the use and not the possession, that's existing law. This bill is not modifying that. That is current. The mandatory minimum is what already exists in our law, and so this bill is not modifying that or changing that. Correct?
Correct.
Okay. I just wanted everyone to be clear that this bill wasn't adding it. Okay, thank you.
Okay. Seeing no further questions, we thank you all very much. We have those coming in opposition to the bill. I see Mark Pennack. Mr. Pennack, please.
Thank you, Mr. Chair. Mark Pennick, President of Maryland Shall Issue. I'm not here to defend auto sears. Auto sears under federal law and its federal definition incorporated in federal statutory law is a machine gun, the part itself. What I'm here to complain about is perhaps I have an aesthetic sense of the law, but it makes a mess out of Maryland law because all you have to do is adopt in 4-401 of the criminal article, the federal definition, which includes parts. Every part of a machine gun under federal law is in fact a machine gun. So there's no sense to me, if you're going to ban machine guns, to ban a particular part of a machine gun. All you have to do is incorporate 5845B of Title 26 into 4-401C of the current Maryland law, and voila, you've now banned all the parts. And you have an existing statutory structure which allows every state attorney to prosecute under that structure, including up to 10 years in prison. It's a very serious misdemeanor. There's no reason to make a mess out of existing statutory law. There's no reason to ban an auto share and not other parts of a machine gun, which is what federal law has done for decades, all parts of a machine gun. So just simply take the federal definition, drop it into existing structure, and you've accomplished every part of this, and indeed more, because you've made every part of a machine gun, not just auto shares, but every part of a machine gun offense that can be prosecuted and has been prosecuted under existing state law. It's really, really simple. Now, the problem with this is not only is it senseless to ban one part of a machine gun and not another part of a machine gun. I mean, that just doesn't make any sense as a legitimate policy point. But you also ban collectors as well. Now, I'm happy to take questions.
Questions, Delegate Aircan.
Thank you, Mr. Chair. Okay, so I read your opposition and understand your concerns are that essentially we would be banning one little piece and then they're going to come up with something new or something different. And then we're just going to have to be back here at the table again because we didn't just outright ban the entire concept. We just ban each piece at a time.
Right. So there's not a lot of sense to me to ban one part and not ban other parts of machine gun when it's already a federal 10-year felony to have any part of a machine gun, just the possession of the part alone. And if you incorporate the federal statute into the existing Maryland structure, you could have the same result, which is salutary. Everybody should be in favor of that.
Okay, so right now, just the possession of it is actually a 10-year felony at the federal level, but they're just not prosecuting the possession of it. Really, that's the essential problem we're having.
So right now, the definition of 4-401 is it does not include parts under the state definition, which is why the state's attorneys can't prosecute under the existing state structure. But that's an easy fix. You just change the definition. And that's all you need to do. And they can prosecute to their heart's delight any part of a machine gun they find. And that's as it should be, because it's been the law for decades for the federal law. You don't have to depend upon the U.S. attorney to do anything. The feds don't even have to take a role. Right now, if you want to prosecute possession of an auto sphere, you have to get the United States attorney to do so, and maybe they're busy. But you don't have to rely on it if you just simply change the state definition to match the federal definition. Voila, done. So easy.
Mr. Penick, thank you as always for being here. I appreciate your passion. My question is, I understand that you have concerns about this bill, so my question is, what would your alternative be? Because in playing that audio, I elevated him, State's Attorney Schellenberger, illustrated the damage that can be done. And so what's your alternative, especially given that, you know these laws very carefully, but clearly they aren't effective because the speaker and Mr. Schellenberger are back asking for this. So what's your alternative?
My alternative is to incorporate the definition in federal law into the state law, and it punishes even more severely than the bill does the possession of an auto sphere, because it incorporates decades worth of federal law, including case law, that allows the prosecution for the mere possession of this. And it's a 10-year, an existing state law, it's a 10-year crime. So my suggestion is actually going to be more effective because it covers all parts of a machine gun, not just an auto share, and it has a more severe punishment for it. No one's here defending auto shares, at least about me.
Delegate Munoz.
Thank you, Mr. Chair. So, Mr. Penick, it sounds to me like you're, rather than just opposed to this because you're suggestion goes even further than the bill we're looking at right now. It sounds more like you're favorable with amendments because you want it to go a little bit further.
I actually struggled with how to title this. It could be favorable with amendment but I ultimately chose opposition because I wanted to highlight what a mess this bill and how it's currently structured makes out of the existing state regulation of machine guns, because it incorporates two different definitions of machine gun that's actually the same definition under federal law, and I can't reconcile that. So rather than play around with support with amendments, it seems to be more straightforward, simply say, don't do this, do that. And that's not a support with amendments, that's the opposition unless you amend. So I'm not sure the semantic difference.
Mr. Pennock, if you know, what is the penalty then for the B under 4306 on the federal level? So here in this bill, it would be the 5-year mandatory up to 20. What would the federal penalty be if someone who uses an assault weapon, rapid fire trigger activator, a switch, auto sear, and the rest?
My recollection that it's a 10-year federal penalty just for possession. There's an enhanced penalty for use of a machine gun in a federal crime, but you can also amend this bill to simply say possession of a machine gun, not just auto shears, but machine gun in a violent crime would also be the same kind of penalty that current law has. Just change from auto shear to machine gun, you're done.
Delegate Conaway.
Thank you, Mr. Chairman. Thank you for coming in to testify. Would the bump stop or stop? Would that be considered as a machine gun also?
No, that has a separate definition, and we're not asking for a change in that. That's the existing
Right,
law.
I understand that. I was trying to get around to this being a part of a machine gun. So the auto shear auto sear is supposed to be a part of a machine gun.
Well,
If you take it
no.
off, then it's going to be not a part of a machine.
It's not now, either under federal law or state law. It's not defined in the state law as a machine gun. State law is set forth in 4-401, and a bump stock doesn't contain an auto shear, for example.
Okay. Right.
So it has a separate prohibition in the existing statute in 4-301. So those prohibitions are, as they are, and we're not suggesting any change to that.
I understand that.
So what you have is an existing definition for machine gun, which is inadequate because it doesn't include parts.
So what I'm trying to get around to the auto shear part, does that only fit this one particular type of gun, or?
It actually, no, it's actually most machine guns, not all, but most machine guns contain auto shears. So the downside to this is you're going to take an existing collector who has gone through all the hoops, and they're substantial, to collect a machine gun properly made before 1986, May 13, 1986, which is when the FOPA was passed by Congress. And they're now like $20,000, $30,000 a piece. And jumped through all the hoops with the ATF, has in fact registered under 4-403 with the state police, is a legitimate possessor and legal for him to possess it under state law currently, because he registers every year, $10. And that puts that person at risk for prosecution for possession of an auto shear, which his machine gun may well contain. So what you're doing is taking the collector and you're opening up the legal liability that he wouldn't otherwise have, because he now may technically possess an auto shear, whereas before he was insulated by the existing structure. So why are you punishing collectors? They're not the problem. The people who are in Baltimore attaching these little devices to their Glocks, they're the problem.
Baltimore, thank you so very much.
Sorry about that.
Further questions? Seeing none. Thank you very much. That concludes the testimony on House Bill 810. Going now to House Bill 430. Delegate Hill. I don't believe you have a panel.
I don't believe I have a panel either.
Okay.
I suspect I have some opposition. Good
Delegate Hill.
afternoon, Mr. Chair, Madam Vice Chair, members of the Judiciary Committee. I'm Terry Hill. I'm presenting for you today House Bill 430. I hope you also received an amendment, because we're really offering this with an amendment. House Bill 430 would simply require that owners of firearms carry liability insurance. And we see this as a bill that both promotes responsible gun handling practices, creates a opportunity for victim compensation, and it provides protection for firearm owners. And you can see from my written testimony, we've written some of that out. And I'm not going to go through the statistics again. You have that in writing. But essentially what the bill does, it prohibits individuals from wearing or carrying firearms in particular circumstances without obtaining liability insurance. The bill as introduced does accept law enforcement and military personnel, and we had offered an amendment that we really would like you to take up that would also exclude local law enforcement. It establishes procedures for issuing citations for violators and for scheduling trials if they want to protest the citation. And it requires liability insurance to cover property damage, bodily injury, and deaths resulting from firearm use. We've heard from a number of people in opposition, and I've had a number of conversations with people asking questions such as, do such policies even exist? Is there such a market? And the reality is that many homeowners and business insurance already carry such provisions. And there are also some standalone firearm liability insurances that are available. And I believe we uploaded an example of one from the U.S. Concealed Carry Association. So they offer liability insurance as well. This is the bill that we're presenting to you for consideration. We asked for the amendment that again would exclude local law enforcement, and we've had discussions with local law enforcement as recently as today, and those who have submitted testimony, and they have indicated to us that with the amendment, they might indeed be in favor of the bill, particularly, and this is from having spoken with someone from the Maryland Chiefs of Police Association and the Maryland Sheriff's Association. In addition to the amendment that we have, which would exempt local law enforcement, they would also like to be sure that that exemption covers officers both on and off duty. And we are certainly open to that. And with that, I believe that they will speak for themselves if they're here, that they would be in support of the legislation.
We have questions. We'll go to Delegate Kaufman and then Delegate Williams.
Delegate Hill, for full disclosure, I'm a proud co-sponsor of the legislation, but I have a question for you, given that a lot of the gun rights organizations are opposed. And I have two questions, if that's okay, Mr. Chair. My first question is, don't you think that if your legislation passed, I've spent a lot of time in the hospitals, and sometimes I've literally come out with a bill that's like almost close to $100,000 or something. But don't you think that your bill would actually be beneficial to gun owners, so that if they accidentally shoot somebody or something, they're not going to go bankrupt because of somebody's medical bills? So that's my first question about how this is actually, do you think that this bill actually prevents gun owners from losing their shirt in the case of an accident? And also my second question is, and I know the pushback is going to be, oh, well, this is a constitutional right, but it's the only constitutional right I know of that has the potential to harm people. But don't we, I think, don't we also require that people buy auto insurance if they own a car?
Well, thank you, Delegate Kaufman. And first of all, I appreciate your support, and I appreciate the question. So yes, we listed in the written testimony a couple of benefits. So first, to gun owners, there is financial protection. Crucial financial protection covers costs associated with unintentional firearm injuries, deaths, thefts, and legal proceedings. There's mitigation of legal risks and promotion of a safety culture. So we already have rules about how far firearms are to be handled, say in the home. But we do know, and I can tell you as a physician, that as much as I hate having to carry liability insurance, there is no question that I'm do a much better job of crossing my T's and dotting my I's because of it. Okay. So I think that we know that liability insurance can also improve
good behavior. For victims and their families, there's an opportunity through this for compensation, legal protection, promotion of safety, and for state medical personnel and other officers. Again, there is an opportunity for financial relief through this, transferring the economic burden of firearm-related incidents from the taxpayers to gun owners. And we actually have broken down for you some numbers for Maryland, where in 2021, firearm injuries, we had 796 deaths and 1,363 injuries, and a total average gunshot wound verdict cost of $727,000. So there are direct and indirect costs. And we believe that, frankly, the insurance industry is optimally set up to mitigate the damages on all areas, and that this would have benefits all around. Thank you.
Question was, don't we already require automobile owners to have auto insurance though? So this is not unprecedented.
We do, but I would say from speaking to the opposition, they would argue that, driving an automobile is not a constitutional right, whereas carrying a firearm under our current constitutional interpretations by the Supreme Court is a constitutional right. And what I've said to them is what I would say to you is I would leave that up to the courts to decide.
Yes, absolutely. Thank you, Delegate.
Thank you.
All right, very briefly here, before we take a couple more questions, I'm going to go to the Vice Chair for an announcement, then we'll go back to questions. Vice Chair.
Thank you, Mr. Chair. And this is quite appropriate because we have Delegate Hill, who is also a member of Alpha Kappa Alpha Sorority Incorporated. And could all members of Alpha Kappa Alpha please stand up? I have the pleasure of being joined by my president of my home chapter, Psi Epsilon Omega, and we have other members of Psi Epsilon Omega here. Thank you very much for being here. As you know, you have your delegates here in this committee, and this is, as we know, one of the hardest, if not the hardest working committee in the General Assembly. So you're in the right place. Thank you. Thank you, Mr. Oh, and Mr. Chair, Mr. Chair made sure that he is color coordinated with us today. So thank you, Mr. Chair.
Whatever the Vice Chair wants. I've learned. All right. And the Vice Chair has to go to do a bill hearing in HGO. So apologies for that intervention, but we wanted to make sure we did that and recognized the people who are here. And now Delegate Williams, then Eric.
Yeah, and I think I've already answered my own question. And I appreciate your amendment, Delegate Hill. And so it appears that the amendment covers, I guess, kind of the concerns, not just of the police and sheriffs, but also from MTA as it applies to state officers as well as police officers within our state agencies as well. Is that correct?
That's my understanding. We have not heard from them specifically that they would change their position with the amendment, but based on their written testimony, I would expect that they would. And again, we're also open to the additional amendment to cover on and off duty.
Okay. Oh, that was my next question, because I noticed the amendment was solely while on duty or while traveling back and forth.
But we understand that our law enforcement have responsibilities even when they're not on duty.
That is correct. They're required to carry even when they're not on duty. Okay. Thank you.
Thank you, Mr. Chair. Thank you for being here, Delegate. Are you familiar with the Bruin case?
I am.
Okay, and so then you probably know that under that, there was a very, very simple test that they crafted so that we could assess the constitutionality of all gun laws. Are you familiar with the test?
You're talking about the historic test. Yeah, in fact, I had a bill last year that I would have introduced. And then I had some consultations, and it was going to be in conflict with some other things were going on that would have said that the right to carry extends as long as the firearm you're carrying would have been in existence then, so that if you had a musket, you didn't need to have a permit, but anything since 1875 or whenever the date was would be, but that we didn't go with that. So yeah.
Well, I don't want to blow your mind, but actually machine guns existed back then. They weren't owned by a lot of people, but they already existed. So do you think that this law, bill is written, would satisfy the historical context?
I'm not a
requirement?
lawyer and I'm certainly not a judge. And that's why I said that I believe that there's some the question that Delegate Kaufman asked, that those are things that if this were to pass, we would certainly, as all the legislation goes through, there'd be an AG opinion about whether this could go into effect and then and so forth. And so I think that my understanding, we haven't asked for an official opinion, but my understanding, having had some consultation with the AG's office, is that they don't feel they'd have a problem defending this bill.
Interesting. So there's some evidence of gun owners in the late 1700s being required to carry insurance?
You're asking me, I'm not a historian either. I didn't know you were, but that I'll accept that.
I am about guns. Thank you.
Thank you.
Don't see any other questions. Thank you very much. That concludes the testimony in favor of the legislation. We'll go. Oh, I'm very sorry. Wait a minute. We were joined by people here from the Economic Matters Committee who came in so quietly that I didn't realize that they were here. I'm very sorry. Do any of you have any questions you wish to ask Delegate Hill? No? Okay.
Thank you.
Now we'll go to those people in opposition. And so if you do have questions, I apologize that I missed all of you. Just let me know and we'll go from there. All right. Taylor McKee, Kathy Wright, Kirsten Rader, Carl Schinner, and John Jocelyn.
You want to share?
We only have 3 chairs up there because we usually have 5. And if you want to grab a chair from the audience and bring it forward, I'm happy to do that. Okay, chairs were taken. We're currently investigating it. There we go. So if we'll go from my right, your left, and we'll go across. So please, sir, go ahead.
Mr. Chairman, members of this committee, thank y'all for having me today. Taylor McKee with the National Rifle Association, and we're opposed to this bill. Firstly, the Bruin standard is that the government must demonstrate and justify its regulation by demonstrating that it's consistent with the nation's historical traditions of firearm regulation. And like was stated earlier, we do not believe in the late 1700s that there was such a liability insurance requirement. And only law-abiding gun owners will comply with this legislation. Criminals will not. So the people causing the harm and damage to their communities will not be the one who participate and comply with this law. Not to mention, insurance doesn't cover illegal and unlawful acts, and therefore would not cover any damage done. This would essentially amount to a tax or a fee to exercise your Second Amendment right, and it would disproportionately impact and discriminate against those with lesser economic means and put them at a disadvantage when it comes to protecting themselves and their families. I'd also point out that the only way to ensure enforcement of this policy would to have a gun registry to check against it. But primarily, insurance doesn't cover intentional acts and only applies to accidents, meaning that these companies would not make payouts to the victims of an intentional crime. The only remedy available to those would be a civil action, as is usually the case. I'm also curious what happens when a person cannot get insurance, whether through an insurance provider or one who could literally not afford it. For these reasons, the National Rifle Association opposes the legislation. Thank you, Chair.
Good afternoon, Mr. Chair, members of the House Judiciary Committee. My name is Carl Schinner. I'm the president of the Maryland Chiefs of Police Association. An amendment was mentioned earlier. We read it about an hour and a half ago, and it did not exempt officers who are off duty. Earlier this month, 2 off-duty police officers engaged an active shooter at the Lakewood Church in Houston. How many people would have died if those officers weren't there carrying their firearms off duty? Those officers ran towards danger. They ran towards gunfire while everyone else ran the other way. They engaged the shooter and stopped others from being slain at church. Unfortunately, House Bill 430, as written, does not exempt off-duty officers. According to the website Gun Violence Archives, there have been 24 mass shootings in the state of Maryland in February. One of those, and two others, or there's been two in the state in 2024. Mass shootings happen in Maryland, and House Bill 430 would make Marylanders less safe as written. Over the past few years, we've seen mass shootings in Aberdeen, and we've seen them in Annapolis. Aside from House Bill 430 as written being unacceptable from the public safety perspective, it's extremely problematic as it would further hinder both recruitment and retention efforts and would most certainly be costly to law enforcement agencies. Law enforcement officers carrying a gun while off duty is not optional for many of them. It's a job requirement. Across the state, agencies are struggling to recruit officers and to keep current personnel. This bill would make it even more difficult if officers had to pay for their own personal firearm liability insurance. If coverage can be found for firearm liability insurance. Thank you. The cost of the insurance would be a burden on law enforcement agencies, and those dollars that could be spent on pay, benefits, equipment, and training would have to be diverted to firearms insurance. That's why the Maryland Chiefs and Maryland Sheriffs Association urge an unfavorable report on House Bill 430 as written.
Good afternoon, Judicial Committee members. My name is Kirsten Rader. I'm 14, homeschooled, and have been a member of the Howard County 4-H Bullseye Club for 5 years. I am also one of the club officers. The 4-H Bullseye Club is a youth shooting sports club with 3 disciplines: shotgun, rifle, and archery. 4 years ago, I accompanied a representative at the State House to learn more about the government. Coincidentally, House Bill 4 was being heard. It could have negatively affected 4-H shooting sports. That day, I was promised by the representative that no harm would ever come to 4-H shooting sports. However, I've needed to come here twice in the past year to remind people about the promise. Last year, I testified against Senate Bill 86 with fellow 4-Hers. Passing this new House Bill 430 will impact youth shooting sports by raising our dues to cover new expenses. It can also affect our coaches who store and transport our firearms. According to a study at Clemson University, youth shooting sports are 45,000 times less likely to cause an injury needing medical attention than youth soccer. Requiring insurance is an overreach, and we don't even know if insurance companies will even cover youth shooters. Teens and adults who cannot afford insurance will have their constitutional rights stripped from them because of their income status. Second Amendment rights should not just be for higher income households. As a result of being in 4-H, I have learned firearm safety, discipline, leadership, restraint, respect, public speaking, and many other life skills. I began shooting because of a medical condition that kept me from playing other organized contact sports. By passing this bill, you are punishing us and future 4-Hers. I invite you to come to our mandatory March club safety meeting or to attend any of our shooting practices. Invitations are on your desk. Passing this bill will have the opposite effect on what you are pursuing. Instead of encouraging and educating responsible gun ownership, which 4-H does, children and parents could be fined or permanently lose their Second Amendment rights if this current bill passes. It will place an additional burden on our club and possibly jeopardize its future. All right, protect our club and reject House Bill 430.
Thank you, Mr. Chair. My name is Kathy Wright, and I'm the Vice President of Legislative Affairs for the Maryland State Rifle and Pistol Association. This legislation will impact hunters, trap shooters, range shooters, and even youth groups, such as 4-H and Scouts. So a person who is teaching a scout troop firearm safety and marksmanship at the range inserts a magazine into a bolt-action single-shot .22 rifle, she could be held liable for not carrying insurance? Yes? Only law-abiding citizens who lawfully own guns will be subject to this regulation. How will criminals be subject to this regulation? This insurance will not cover criminal acts, and how would this prevent violence? It is unclear whether the mandated insurance coverage even exists. What happens when a person can't get coverage? In other states, such as in New Jersey, there were instances where gun owners could not find concealed carry liability insurance policies. This bill does not address this glaring oversight. And this bill discriminates against those with lesser economic means. The state would need a registry for guns and insurance to know who has or does not have coverage. Was this the purpose of this legislation? To establish a gun registry? This is basically a fee to exercise a constitutional right. This insurance mandate unreasonably burdens a citizen's Second Amendment right to carry a firearm in public for self-defense, thus making it unconstitutional. We request an unfavorable response. Thank you.
Good afternoon, Mr. Chairman, members of the committees. My name is John Jocelyn. I'm speaking on behalf of 2A Maryland. The title of this bill is incredibly misleading. It would lead you to believe that it's limited only to persons who are carrying a firearm with wear and carry permit. That is untrue. It applies to any person who has a firearm once they have put a round in the chamber. So everybody that has a firearm, the moment they load it, they're required to have the insurance. If you go to a trap range, you step up to the field, you don't need insurance. You drop a round in the chamber, now you need insurance. You shoot the round, gun's now empty, now you don't need insurance. Anybody who takes the HQL course has to fire the firearm, which would mean anybody who's going to take an HQL course must first get the liability insurance. If they don't have it, and I as an instructor teach someone who doesn't have it, am I now an accessory to a crime? Do I incur liability because my student didn't have the insurance? How am I to determine that they have it? Is there any standard means in terms of law enforcement? Is there any mechanism in this bill that allows law enforcement to determine who does and who does not have an active policy? Showing a certificate of insurance doesn't mean you didn't cancel it the day before. There's no mechanism to enforce this, but you risk losing your firearms rights if you don't. We heard today about the Glock switches and the problem that they engender. Does anybody in this room believe that someone who is carrying a firearm with one of those attached would get insurance? We're looking at a bill that is directed at the law-abiding citizens. It exempts the criminals because if they tried to buy the insurance, they're not allowed to have a firearm to begin with. This is a bill that doesn't have a purpose, serves no positive thing, hurts a lot of law-abiding people, especially the youth groups. We ask for an unfavorable report. Thank you so much.
Thank you, Mr. Chair. Thank you all for being here. I just had a couple questions for Kirsten. First, thank you for coming back again. I'm sorry that we have not kept our promise to you thus far. I was just quickly searching to see if people under 18 could purchase even car insurance, and it turns out it won't shock you to know, no, they can't purchase it on their own. So I think your point was really interesting that hadn't crossed my mind yet. How many kids do you actually have in your club? Who's doing this?
I'm not sure about like the exact number. I would say close to about 100.
Thank you so much for being here again, and hopefully this will be the last year we drag you down here for something that will inhibit your ability to play your sport.
Thank you.
Seeing no other questions for this panel, thank you all very much. Go now to Michael Shire, John Hines, Mark Pennack, Carla Mooney, Clyde Boatwright.
Good afternoon, Mr. Chair, members of the committee. My name is Clyde Boatwright, President of the Maryland State Fraternal Order of Police, here in opposition to this piece of legislation. As you heard, there is some amendments being discussed that would essentially not force police officers to be covered under liability insurance. I want to draw your attention to December 7th, 2023. I'm going to mention two names that people may not know who they are. That's Kenneth and Axel Hobson, I believe their names are. Dotson, I'm sorry. I'm going to get it correct. Kenneth and Axel Dotson. These two gentlemen are retired NYPD police officers vacationing in Atlanta when they noticed a woman trying to burn Dr. Martin Luther King's home down, and they stopped her. They were retired police officers who saw something and did something. After 9/11, under the Patriot Act, the United States government saw fit to pass HR 218 that allowed police officers to carry active police officers and retired who get LEOSA to carry firearms anywhere in the United States. We are trying to keep our Maryland retirees here in the state of Maryland, but we do feel also that this would be a tax on our retirees and force them to leave. So we're asking that retired police officers who see something and do something. We ask people, if you see something, say something. Our retirees actually do something. So we want to keep our retirees in good standing and ask that they be covered along with our on-duty police officers. And I'll be available to stand for any questions.
Good afternoon again. Mike Shire with the Maryland Fraternal Order of Police, speaking in opposition for this bill as written. We appreciate that the sponsor Delegate Hill is open to amendments. We have seen the ones that she's drafted so far. Unfortunately, they do not go quite far enough. As she mentioned, we do need to cover off-duty police officers as well. The Law Enforcement Officer Safety Act that Mr. Boatwright mentioned covers all law enforcement officers in this country and allows them to carry their firearms across state lines anywhere in this country. That's why you had NYPD officers in, I think it was Atlanta, he said, being able to do something in those cases. So we do appreciate that there's amendments, but I would ask that they be expanded. If you look at last year's Senate Bill 1, what's now codified as Criminal Law 4-111, I believe there are exemptions in there that would satisfy if they can be copy and pasted over. The Fraternal Order of Police would certainly be satisfied. Just as a note, our police officers go through extensive training over the years of their service. And when they are retired, they have to continue to qualify annually on their firearms to ensure proficiency. So it is it doesn't make sense to require police officers to carry insurance when we are constantly being trained, qualified. As was mentioned, we agree with the Chiefs of Police Association. This is not good for our recruitment and retention. As you heard yesterday, we are suffering greatly from that. We do not want to discourage police officers from continuing to be in this profession. I will be retiring in hopefully 4 years. I'll have 24 years as a law enforcement officer at that point. And I hope to be able to carry my firearm so that I can do something if the need arises. I'm proud of my service. And even as a retired police officer, I hope to be proud of my service continuing forward. As for those amendments, and in light of those at this point, their absence, we stand in opposition. Thank you.
Mr. Chairman, Mark Penlick, President of Maryland, shall issue. So the bill is written very broadly to cover anybody who wears or carries a loaded firearm. And that includes LEOSA officers, active duty and non-active duty, retired officers. It includes anybody on a range that loads a firearm. It includes anybody who has a wear and carry permit, but it's not remotely limited to those people. But in any event, no matter who is covered by this, it is grossly unconstitutional. There is a case in point by the Federal District Court in New Jersey, which this bill is copied off of, that has held the insurance requirement that is virtually identical to one you have before you to be unconstitutional. That decision has been appealed by the New Jersey Attorney General. It was heard in oral argument by the Third Circuit in October. Expected a decision at any point. I would urge you to listen to the oral argument. I don't think there's really any dispute that there is no historical analog under Bruin that remotely would authorize this sort of requirement. This bill creates a firearms disability of all firearms, not just handguns, rifles, pistols, shotguns. You may not possess them unless you carry this insurance. This is a gross violation of the Second Amendment, and we will litigate it if it becomes law. I promise you that.
Hi, thank you for having me today. My name is Carla Mooney. I'm from the 29C, and I am the director of the DC Project Women for Gun Rights for Maryland, and also the state leader for the Armed Women of America. I represent my ladies in both groups and a number of many more than just myself. I'm also a professional multidisciplinary firearms instructor and a Maryland QHIC. I've read this bill and have quite a few roadblocks in mind. First, it seems very unconstitutional to require insurance to exercise your right to keep and bear arms. It is unduly burdened to the citizens to have to pay additional money to wear and carry a firearm. Second, I think that it subjects to challenges under the equal protection clauses of the 14th Amendment to the United States Constitution. This law treats certain groups of people differently in terms of firearms possession, disqualification, or insurance requirements. Laws affecting individuals' rights to possess firearms must provide adequate procedural safeguards to ensure fairness. Challenges could arise if the law is vague or if it fails to provide individual proper notice of the opportunity to be heard before the rights and for restrictions. Mandating liability insurance for firearms carry could raise challenges related to insurance regulations. States have regulatory authority over insurance matters, and there may be questions about whether such requirements fall within their control. Based on research, there doesn't seem to be a current liability insurance that truly would handle this type of restriction. Therefore, something would have to be written. I wonder myself, who would benefit from newly regulated insurance policies? What kind of riders out there are connected to our bill rider or their family members? It seems to me that this could cause someone from inside to have. I ask for unfavorable review of this bill.
Questions? Delegate Schmidt.
Thank you, Chair. Mr. Penick, you had mentioned the New Jersey case. Are there other states that either have proposed this law or other states that are holding?
No other state has this law, only New Jersey. The city of San Jose, is discussed in my written testimony, had a similar law but did not impose a firearms disqualification. So that was at most defined. So this would be the first, apart from New Jersey. Not even New York in their comprehensive carry legislation that was enacted after Bruin dared go this far.
Thank you.
Delegate Tomlinson.
Thank you, Mr. Chair. I know that I know none of you represent the insurance industry, but I'm looking at this letter from the Maryland Association of Mutual Insurance Companies, and they talk about there's simply insufficient data for small and medium-sized insurers to responsibly create rates that reflect the exposure to loss. And I know in your written testimony, you talk a little bit about insurance. Can you comment on that?
Yes, so the problem with getting commercial insurance, and from my research, is very rare to get this from any nationally or regional insurance. There's a quote in the Forbes article that I quote in there to that effect. There may or may not be available in some states, not all, but I'm not sure it's available in Maryland. But the problem with this kind of insurance is that the insurance companies have to make an assessment of risk in order to assign a premium. So they don't have the data for that, to do that. So, and they're going to be reluctant to undertake the reputational risk associated with insuring against firearm policies specifically, and only firearms policies, without that kind of data. Now, my homeowners doesn't necessarily cover it. It covers accidents, liability, but it doesn't say a word about firearms. Now, I have a national insurance policy for my homeowners, but I'm not sure that when a push comes to shove, they're going to cover an accident with a firearm. And without knowing that, and they don't have to tell me, I'm not sure that I would be covered, even though it's hundreds of thousands of dollars worth of coverage. So I'm in a state of uncertainty as to whether or not my homeowners is good enough. And I don't know that I can get it anywhere else.
Seeing no further questions for the panel, thank you very much. That concludes the testimony on House Bill 430. We'll go to 947 now, and Delegate Phillips. Ask Delegate Phillips, Kelly Simpson. We need Mary Kanaa, who is virtual. And the Attorney General? Who else do you have joining you?
Aaron Earp, Giffords Law Center.
Okay. All right. Delegate, whenever you're ready, please.
All right, thank you, Mr. Chair, and appreciate this opportunity. Mr. Chair, Vice Chair hasn't gotten back yet. For the record, Delegate N. Scott Phillips, 10th Legislative District, and I'm before you today to request a favorable report on House Bill 947. This bill was also cross-filed by the Vice Chair of Judicial Proceedings, Senator Wallstreicher. Before I begin, I do want to acknowledge those behind me, the members of Moms Demand Action. Thank you. History of this bill, it was introduced by Chair Vanessa Atterbury and Delegate Rosenberg in the last session. Let me say this. For nearly 2 decades, the federal law known as the Protection of Lawful Commerce in Arms Act, PLACA, has shielded bad actors in the gun industry from lawsuits that would hold them accountable for their role in fueling the epidemic of gun violence. This broad protection has prevented individuals and communities injured by gun violence from filing civil suits against these bad actors, giving the gun industry little incentive to change their dangerous and irresponsible practices. This bill will prohibit certain firearm industry members from knowingly creating, maintaining, or contributing to harm to the public through the sale, manufacture, transport, or marketing of firearm-related products under certain circumstances. The bill will require a firearm industry member to establish and implement certain reasonable controls and policies regarding the sale, manufacture, alteration, importation, distribution, marketing, possession, and use of certain firearm-related products. This bill will establish that violating this act is a public nuisance. Now, I'm going to say a couple of other things. Under this act, the gentleman sitting to my left, the Attorney General, would be authorized to bring an action against the firearm industry for violating this act. In an action brought by the Attorney General, they would be able to seek injunctive relief, restitution, compensatory and punitive damages, reasonable attorney's fees, and any other appropriate relief. The folks here on this panel are going to give you some more details about the bill and walk you through it. This bill is about holding bad actors accountable, and there are bad actors. A great example is Polymer 80. If you have been watching the news, a firm which was recently reached a $1.2 million settlement for facilitating the illegal sale of ghost guns in Baltimore City, as well as communities around the country. For this reason, I am asking the Judiciary Committee for a favorable vote on House Bill 947. Mr. Attorney General.
Thank you. Good afternoon, Mr. Chairman and members of the House Judiciary Committee. For the record, I'm Attorney General Anthony Brown testifying in support of HB 947. I want to commend Delegate Phillips for his leadership on this bill and providing the Office of the Attorney General with an important tool for holding the gun industry accountable for its contributions to the crisis of gun violence in our communities. On average, guns kill nearly 800 people each year in our state, and 5% of gun dealers are responsible for 90% of recovered crime guns. The gun industry has done far too little to keep guns and ammunition out of the hands of those who are not allowed to have them or who would use them to do harm. In 2022 alone, federal firearms licensees reported the loss or theft of some 17,000 firearms, and the gun industry has a history of marketing its products to young people and those most prone to commit acts of violence. Under PLACA, which the sponsor mentioned, the firearm manufacturers and sellers are immune from suits, regardless of how blameworthy their conduct may have been. However, if a gun manufacturer or seller violates a state or federal statute governing the sale or marketing of guns and ammunition, a predicate statute, a suit to redress the resulting harm is not barred by PLACA. And PLACA provides examples of suits that would fall within the predicate exception. And with my limited time, I'd ask you to look at my written testimony for those examples. House Bill 49 would add a predicate statute to Maryland law, enabling firearm manufacturers, sellers, and marketers to be sued for their irresponsible conduct without running afoul of PLACA. HB 947 would prohibit conduct that is unlawful or unreasonable. It would require reasonable controls. They're outlined in my written comments or testimony. It would authorize the Attorney General to sue firearms industry members for such unlawful or unreasonable conduct. Passing HB 947 would place Maryland among 8 states that have passed similar statutes. None of those state statutes have been vacated or overturned on constitutional grounds. Some of them are pending in federal court. I urge the committee to adopt a favorable report on this bill.
Good afternoon, Mr. Chair and members of the committee. My name is Erin Earp. I'm a state policy attorney for the Giffords Law Center and a resident of Calvert County, Maryland. HB 947 would help to ensure that bad actors in the firearm industry behave responsibly, and it would also reopen courtroom doors for victims of gun violence who have been shut out for too long. It would prohibit industry members from endangering public health and safety through unlawful or unreasonable conduct. And it would also require firearm industry members to implement reasonable controls to prevent loss and theft and to prevent the sale or distribution of firearm-related products to individuals who we can all agree should not have them, specifically straw purchasers, firearm traffickers, prohibited persons, and those who intend to commit a crime or cause harm to themselves or someone else. These standards are consistent with those followed by almost every other industry. Unlike other industries, the firearm industry currently enjoys immunity under PLACA, as previously stated. However, that immunity is not absolute and provides explicit exemption for laws at the state level that regulate the sale and marketing of firearms. PLACA invites the state regulation. It does not preempt it. Under this bill, should firearm industry members fail to implement reasonable measures, victims of gun violence would now have an avenue to obtain justice in court, just as if they were harmed by the negligence of other types of businesses. It would also allow the Attorney General to file a cause of action to hold bad actors in the industry accountable. This bill simply requires firearm industry members to behave reasonably and responsibly and would restore accountability for an industry that has too long acted with impunity, acquired at the expense of public health and safety. And Giffords urges a favorable report on HB 947. Thank you.
Chair Clippinger and distinguished committee members. I'm Kelly Sampson, Senior Counsel and Director of Racial Justice at Brady. We support HB 947. Negligence is an uncontroversial, centuries-old legal standard that requires us all to use reasonable care to prevent foreseeable harm and holds us accountable when we don't. That's why the civil legal system already accommodates claims against reckless and irresponsible actors in every other industry. This bill would merely hold gun industry members to the same standard because no industry is above the law. To be clear, this bill is about gun industry members facing civil consequences for their own actions, same as you and me. Say, for example, that John Doe barrels into the town gun shop and agitatedly says that he's really angry at his wife. Then the shop proceeds with the sale merely because John passes a background check and has a license. The next day, John shoots and kills his wife, Jane. In this case, John would face criminal charges and possibly civil ones too. Without this bill, however, the shop could evade responsibility because it followed the law. But with this bill, Jane's survivors could at least have the chance to bring a claim that the shop was unreasonable and should have foreseen that selling a gun to an agitated customer who was really angry at his wife would cause harm. In addition, it would send a message to other gun dealers that they should take different steps to prevent such harm in the future. Now, whether or not the shop ultimately faces liability depends on the court, but without this bill, Jane's family wouldn't even have a chance. This bill is about people like Jane who suffer from irresponsible actors, but most gun industry members do act responsibly, and responsible members will have nothing to fear from this bill. It neither creates strict liability nor guarantees a favorable judgment. At bottom, this bill falls squarely within PLACA's predicate exception and corrects unintended overreach that has allowed some in the industry to put profits over people. This bill simply ensures that the people of Maryland have an opportunity to hold the gun industry accountable. I urge a favorable report.
Questions for the panel, Delegate Kaufman. Oh, I'm sorry, we have the person online. I beg your pardon. Mary Kana.
Good afternoon, Chairman Clippinger and members of the committee. My name is Mary Kana, and I am Policy Counsel for Everytown for Gun Safety here on behalf of our volunteers across Maryland. No other industry in the country has been granted the broad immunity PLACA affords the firearm industry. When gun dealers and manufacturers engage in irresponsible business practices that result in preventable harm, PLACA shields these bad actors from liability. While that shield is broad, it is not absolute. PLACA contains several exceptions identifying cases where gun industry members, be they manufacturers, wholesalers, or retail dealers, can be sued by those who are harmed by their products. Bills like HB 947 create state laws that, if they are violated by a gun industry member, will provide the state and individuals power to hold them accountable. When bad actors in the gun industry face civil litigation and the risk of incurring financial loss because of their unsafe business practices, they will finally have an economic incentive to establish reasonable controls set forth in this bill. Since 2021, 8 other states have passed laws like this. These laws have withstood legal challenges. They have enabled the filing of several cases against bad actors in the gun industry whose misconduct has caused death, injury, and other harm. For example, Washington won a settlement against a gun dealer unlawfully selling high-capacity magazines. New Jersey is currently pursuing lawsuits against 2 Pennsylvania gun dealers who were unlawfully supplying ghost guns within the state. They are also suing a gun dealer whose lax security permitted dozens of guns to be stolen and subsequently used in crimes. The city of Chicago was able to close the largest supplier of its out-of-state crime guns. Without their industry accountability laws, this would not have been possible. Passing HB 947 would require members of the firearm industry to establish reasonable controls around the sale of their products, enable the Attorney General to investigate those who fail to do so, and provide access to justice for Marylanders harmed by bad actors in the gun industry. Thank you for your time. I urge a favorable report.
Now let's take questions. Delegate Kaufman to begin.
Thank you,
Eric
Mr.
And then Tomlinson.
Mr. Attorney General, it's always a pleasure to see you. I'm sure we're going to hear from the opponents that this bill does not comply with Bruin and that there wasn't something in the 1800s that dealt with this. So I just wanted to know. I wanted to preempt the question and hear from you why you felt that this legislation meets Bruin.
Let me start by thank you for the question. And I wouldn't be sitting here today if the Office of the Attorney General didn't believe that passing this bill was defensible, that it will survive constitutional challenges, whether those challenges are based on the Second Amendment or any other challenge, and that this bill will withstand any challenges to statutory construction of PLACA, what it means, whether this satisfies the requirements of a predicate law. So we are prepared to defend that and are confident that we'll be able to do so successfully.
Delegate Eric.
Thank you, Mr. Chair. Thank you all for being here. Mr. Attorney General, I appreciate your comments. Of course, we also all saw what happened with SB1, and you were very confident that you'd be able to defend that as well. But obviously, most of the substantive portions of that bill have been enjoined. So with that in mind, could you just touch on, first of all, you mentioned that there was some 5% of dealers are responsible for, if you could just give the data again, what percentage of the illegal guns, and then how do you know that and who are they? And then my second question I'll touch on has to do with the other states that are doing this.
And I would actually ask you to review the written testimony where I cite the sources of the data that I included not only in my more detailed written testimony, but as I try to summarize. So I'd ask you to look there. And before you ask your second question, let me just take issue with a point that you made. I would disagree that most of the substantive provisions in SB1 were overturned by the Second Circuit, because in fact, it's quite the opposite. While we did not every safe space that was created survive challenge, the majority of them did. And I never come before the General Assembly and tell you that the bills that you pass are not without risk. But I think you heard in a previous testimony, you've got to take bold action if you're going to protect the public. And some of it will be challenged. And some cases will win, and some cases will lose. But I wouldn't stand here today if I didn't think I could bring a merit-based case that defends the laws that protect the citizens of Maryland.
Along those lines of merit-based cases, you mentioned 8 states. Have any of those passed judicial muster to date? Have any of them made it through the adjudication process yet?
And I think Mary from Everytown probably is more well-versed on that. And I think she's probably the better witness.
That's fine.
to
Mary,
answer
yeah, if you'd like to answer.
None of them have reached the end of the adjudication process, no, and but they have withstood legal muster, though some parts which are not relevant to today's bill in other states have been enjoined.
Okay, I thank you for your answers today, and thank you for being here.
Thank you, Mr. Chair. My question is for anybody on the panel, and I asked this also for some of the moms demand action when they came at this point. It could have been yesterday or a year ago. I don't even know. It's all blur, but I think it was in January, and we had a meeting, and I asked the same question. When it comes to the marketing aspect of this, and the gun industry and the firearm industry, my question is, how does the firearm industry market? And I'm asking that because I really don't know. I mean, I know that in my home county, the closest I could think of it was a billboard promoting a gun show and a billboard promoting or just advertising for a gun store. But I mean, it's just the name, where it's at. It doesn't even have a picture of a gun. And NRA magazine, there'll be ads, but I mean, obviously, if you're reading NRA magazine, you're probably, gun enthusiast. So yeah, my question is, how is the firearm industry marketing? I don't know.
Thanks for that question. I don't have necessarily an exhaustive list of all the ways that the firearm industry markets, but we know, for example, in publications like the NRA magazine, as well as publications such as Garden and Gun, some manufacturers will run ads for their weapons. I think one of the most infamous examples is Bushmaster for a while had a campaign called Man Card Revoked. And it was basically suggesting that if you are a man and you feel emasculated, or if someone you know is a man and you think that they're emasculated, one of the ways that you can capture your masculinity is to get an AR-15 assault rifle. And part of the reason why that was so significant is because we know that there's a connection between people who have feelings, or they're playing on individuals who feel powerless and saying the way that you can gain your power back is to get one of our rifles and to provoke violence. Another example of marketing that we've seen is playing on the military and law enforcement and their service and their duty, and reaching out to people who have nothing to do with those communities, but saying, if you want to engage in warfare and if you want to engage in playing the warrior, get one of our rifles, get one of our weapons, and that'll empower you to have the same experience as law enforcement. So those are just a couple examples of the sorts of ads that we've seen. We also know some companies rely on social media, for example. These are the sorts of things. Obviously, it doesn't mean that there's strict liability for marketing by any means. That's not what this bill is about at all. It's more saying that if your marketing is unreasonable and it leads to foreseeable harm, a person harmed by that would have the opportunity to go to the courthouse doors, and then whether or not that proceeds is like any other case with any other industry, will depend on the merits of your case.
Sorry, Mr. Chair. So with those examples you just used, what form of marketing? Because I can't recall seeing a commercial or like a radio ad, or is this on social media or print?
So a couple of the examples that I mentioned are in print. The Man Card Revoked ad was actually a print and social campaign, and this part they have stopped doing, but part of it was you could send, I believe, a quiz to different friends and say, like, are you man enough? And if not,
nobody's ever sent that to me. Nobody's ever questioned that.
There are plenty of ads that I have
guess
not
that means you're
received as
man
well.
enough. Yeah.
But the point is that these were, as you know, we live in a media market that you have print, you have social media, you have radio, you have all sorts of means. So again, I do not by any means have an exhaustive list of advertisements. These are just a couple of examples.
All right, thanks.
Thank you, Mr. Chairman, and thank you, distinguished panel. I'm trying to get my head around the product liability aspect of this. if someone negligently uses a product, how do you hold the manufacturer liable for the negligent use? Wouldn't it be similar to someone gets killed by a drunk driver, the relatives don't sue the car manufacturer? I'm trying to correlate this. Can you help me with that?
So Mary, do you want to take that one? I see you smiling.
Oh, I think Kelly wants to take it.
Yeah, Kelly was to take that. All right, all right.
Yeah, I mean, thank you for that question because it gives an opportunity to show the distinction here. So what we're talking about is, I mean, I gave an example, but just to drill down on that, we're getting at whether or not the conduct by the individual who sold the weapon or distributed the weapon was reasonable. And so in the instance that you gave, perhaps a person comes into a store and they're showing indications of straw purchasing. So you have two people come into a gun store. One of them is a small, 90-year-old woman who can't even bear the weight of the weapon. And with her is a young man who is clearly doing all the pointing, all the picking. But when you go up to the counter and it's time to fill out the 4473 background check, all of a sudden she's the one filling out the background check. And this isn't coming from me. The National Shooting Sports Foundation actually has a program where they tell manufacturers and dealers and distributors to watch out for signs of straw purchasing. So in that instance, let's say that the individual is in fact a straw purchaser and does use that weapon to harm somebody. What this bill is saying is that that person who is victimized by that action would at least have the opportunity to file a claim and say that was unreasonable. You should have foreseen based on the indications that this will cause me harm. Now, of course, the shooter would also face liability and accountability for their own actions, but the dealer or the distributor who acted unreasonably also would have their own part to play. So it's not trying to hold someone responsible for someone else's actions. It's more, did you act in a reasonable fashion?
The liability fall upon the purchaser illegally of the weapon and transferring it to someone who shouldn't have it. Isn't that where the liability stops?
No, they're not mutually exclusive. So we know for a fact that if someone does something wrong, they can be held criminally liable. They often are. They can also be held civilly liable. What this is saying is that you have to look at the entire universe of what happened. And if someone negligently distributes or sells a firearm, they can be held accountable for that action of the negligent distribution or the negligent sale. That's where the locus of this bill is focusing.
So you're saying that if the straw purchaser deceives the distributor and the manufacturer, they're liable even though they've been deceived?
Not necessarily. I think what you're getting at is what would happen with a case. There are instances where you could look at a situation and say, that was reasonable. There was nothing to indicate that that sale would be problematic. But we know from the gun industry itself, as I said, NSSF has a program, Don't Lie for the Other Guy, where they actually lay out for gun manufacturers and dealers, these are the signs of a straw sale. If you see two people come in like I described, or if you see someone at the counter and they're talking on the phone and they're asking, or if you see someone come in and they buy 50 pistols, day after day after day. These are all signs that you should probably inquire a little bit further and perhaps consider denying that sale. So those are the distinctions between unreasonable and reasonable behavior. And those are things that will be worked out in a court of law. But without this bill, they may never even get that chance.
All right, thank you very much.
Thank you, Mr. Chair. So my question is, why is this bill so incredibly vague? I started looking at the contribute to harm, which is not defined, talking about the marketing. Retrieve your man card is a little weird. It's not illegal. You see similar advertising with Old Spice or energy drinks or coffee. Again, a little bit weird, but incredibly vague. Even firearm industry members shall establish and implement reasonable controls, which is defined, and list various things that an industry member would have to prevent. But there are already various statutes in place that do prevent these things. And the bill seems to be kind of an open-ended, gotcha, you didn't do that one thing. So how is an industry member supposed to, it seems like really just an open-ended mechanism to persecute an industry member after the fact. Because these examples, which, I agree with, you can't buy 50 pistols in a day. There are laws against that. That's illegal. That's not happening. So why isn't the bill more prescriptive if you want to advance it about how an industry member would have to act, as opposed to having these open-ended language about what they could be persecuted for?
So I'm going to jump in and just say this, Delegate Grammer. You cannot prescribe all of the potential acts of a bad actor, right? And I think to be more proscriptive would be a challenge if we want the bill to be, or this act to be effective. The sense on this one is that we would give, once again, this is a reasonable standard. I would not anticipate, 100 complaints coming from the Attorney General on a matter of this nature. What we dealt with, as example, with Polymer 80, and that was a different type of a case because we've outlawed ghost guns, but a similar potential outcome, which is we've got a bad actor. That bad actor has been a repetitive bad actor, and now we need to take some action so that we don't have guns on the streets with people that should not have them.
To that is that the responsibility of this committee is to differentiate between what we should prosecute for and creating these holes, which can be very persecutory. Polymer 80, they ban ghost guns. That's the action we look to go after, and that's the bill we passed, and that's what we got done. But this is extremely vague. Even, prevent a sale or distribution of a firearm related product to a straw purchaser. Well, that's illegal. But how do you cast such a wide net? Anybody could be a straw purchaser. And it's more about the after the fact. Well, I didn't know she was buying that for him, but now you could still prosecute that business for something they could never know.
If I could jump in, and Doug, you started with, I think, an important point that there are statutes in place that govern the conduct, both statutes and regulations that govern the conducts, the requirements for most participants in the gun industry, right? If you're a gun dealer, these are things that you have to do. And if you don't, that's unlawful. You're not in compliance. And there are consequences for that, right? Whether losing a license or some administrative consequence. The reason why this bill is important is because this is the only industry where if there was harm caused by your non-compliance, that a Marylander couldn't seek compensation or redress in the courts. This is the only industry. If you are selling alcoholic beverages and you don't comply with the licensing requirements, the regulatory agency can come down and fine you based on the nature of the conduct. You might be criminally liable, and you can also be sued if your conduct as the store owner contributed to harm. Firearm manufacturers, distributors, dealers is the only industry where that currently doesn't exist, certainly in Maryland, if we don't pass this predicate law. On the second point that you raised about specificity, it really is impossible to enumerate every conduct that would trigger liability. I mean, the General Assembly never does that. And what you've done, and you can look through the code, and you see provisions like what you find on page 3, lines 19 to 25. And it sets out standards that are very common and standards that are used every day in the courts of Maryland to prove cases, right? It taught knowingly create. That's not new in the courts of Maryland. The defense bar, the plaintiff's bar, they know what it means to show knowledge of, contribute to harm. Okay, what's the contribution? Causation. What's the relationship? These are not new concepts. the conduct that is unlawful. I mean, those are issues that are litigated every day in the courts of Maryland, and this General Assembly has not specified in all those areas what's unreasonable. These are arguments that are made by parties and defenses that are made by defendants. So nothing presented in this bill is any more or less vague than what the General Assembly passes every year.
Appreciate the answer, but back to my first point, we still haven't defined what harm is, which is a part of the problem. But thank you for the
harm is
answers.
certainly if someone dies, right? It's not going to be difficult to prove that one.
Delegate Conaway.
Thank you, Mr. Chairman. Thank you, delegate and panel, for coming in today. So my question is in reference to page 3, line 5. What is the makeup of a reasonable cause? Anybody? A person who the firearm industry member has reasonable cause to believe intends to use the firearm related product to cause harm to another person. Suppose if you make the statement when you go to purchase your firearm, this is for the people that keep breaking into my garage. Suppose you make that kind of a statement. Would that be covered under this page 3, line 5?
You want to hear that?
Yeah, I mean, I think reasonable. I just want to make sure I understand the question. Are you asking how would it be defined from the position of the person distributing whether or not someone has reasonable cause?
To your store and said, somebody keeps breaking into my garage, give me that Glock right there and that over and under. Would you have reasonable cause not to sell them those firearms because you believe that they intend to do harm to another?
Thanks for the question. I'm not sure in that particular instance, but I think what we've seen more likely and what my colleagues and I have experienced is something more similar to what I laid out in my testimony, where you might have someone come in and say like, and the key here is that oftentimes these are people who otherwise, like, they could pass a background check. They might have whatever is required in their state, but they may come in and say something like, oh, I'm so angry with Chuck from work and I need to make sure I have a weapon. Things of that nature. Yeah, those are the sorts of circumstances.
About it, we had this when we had to run on these weapons. People were buying guns. They didn't know how to operate the gun. They didn't know what size hand grip they needed. They didn't know what size capacity magazines, what bullets go with what. So therefore, if you come in there to the store and you're asking about all these different things, I clearly know that you are not literate in gun ownership. So therefore, I should deny you because I think you plan on doing harm to
Not necessarily. I
Really?
think it's important in the statute. It talks about the totality of the circumstances,
Right, that's why I
and
asked you
that's
about
the
this.
key. And that's not anything that's special for this. For firearms, that's something you see in negligence law in general. And the reason why that's important is because FFLs, or federally licensed firearms dealers, have discretion. They have discretion to deny a sale for any reason. And the reason why is because in our legal system, we entrust FFLs with a really, really high responsibility because they are the people who are often the last step between a firearm and the public. And so there could be circumstances where someone could come in and go into a gun store and say, I'm really interested. I want to exercise my rights. I've never shot a gun before, but I think I would like to have one. I don't really know much about them. And you as a gun dealer could say, well, tell me more about that. Tell me more about your interests. What are you looking for?
How about if I just tell you
and ask
no
questions.
and you deny me, and then will I have recourse to sue you?
I'm not sure.
Oh, okay. Thank
Actually.
you very much. You're not sure about a lot of things. Thank you so very much.
Okay. You can ask whatever he wants.
Okay. Let me go back to the question with regard to harm. I guess the question, and the Attorney General said certainly killing somebody would be harm. Is it any kind of harm? Would it be, emotional distress? I mean, are we going from anything from it made us nervous to somebody died? Is that the scope of harm that we're looking at here, or is it something more specific?
I don't think you would rule out all of the sort of types of harm that are alleged in tort claims today. I don't think you would rule though I don't think they would be excluded. I think it would be as expansive as that. Yes.
Okay. All right. I'm gonna leave it there. It struck me as certainly one of the questions in tort law, different from certainly criminal law, but I was curious about that a little bit. All right. Further questions for this panel? Seeing none, thank you very much.
All right, thank you, Mr. Chair.
All right. Go to Steve, please. We don't do that. I apologize, but no, we don't do applause. Stephen Corbin, Karen Herron, Jennifer Policonis, Kevin Sullivan.
What's that? I can't.
I mean.
Good afternoon, Chair Clippinger, Vice Chair Bartlett, and the committee. I'm Dr. Stephen Corbin. I live in District 16, and I'm a member of Montgomery County Moms Demand Action. I'm also a veteran, a gun owner, a career public health professional, and father to a family that has survived gun violence. I'm here to support HB 947 and urge a favorable report. 3 years ago, my oldest child nearly died as a result of grossly incompetent handling of firearms by others and being abandoned by our legal system. He and a friend were checking out waterfront property in a rural Maryland county, a routine day. As they walked the property, they heard gunfire. Bullets crashed through the branches overhead. They quickly ducked to move toward safety. Unfortunately, my son was struck by a bullet, later found out to have entered his left scapula, punctured his left lung, fractured a vertebrae, punctured his right lung, and come to rest in his right scapula. There was an EMS response, helicopter transport to Prince George's County Hospital, and a year later, surgery. Police discovered a group of individuals around 300 yards away, beyond a stand of trees. They claimed to have had permission to shoot shotguns and pistols, including a 9mm semi-automatic Glock pistol, at targets they said were skeet or objects on a log. The police never identified which shooter was responsible for the bullet that struck my son. A police report recommended charging reckless endangerment. The state's attorney took no action. This irresponsible behavior would simply be ignored. No charges, no warnings, no weapons confiscations, no mandated education, no fines, no public accountability, nothing. Had my son died, could it have been swept under the rug? Physically, he's recovered, but not mentally and emotionally. And he's disgusted and outraged that these cavalier attitudes can persist. He won't be buying any property there. There is so much more that can be done to make us safer.
Thank you. Thank you very much.
Good afternoon. I'm Karen Herron from Marylanders to Prevent Gun Violence, here today in support of HB 947. Since the bill's purpose has already been well covered, I'll focus on the oversight systems in place for the industry. I'll begin by saying that the vast majority of firearm dealers are doing their best to run responsible businesses and take their role as dealers of lethal weapons very seriously, abiding by the law and often going beyond. We do not dispute that. However, the exceptions to that are not easy to rein in. As you know, the ATF has regulatory oversight over firearm dealers in the U.S., but the scope of their work is limited. Nationally, there are over 132,000 firearm dealers and 9,100 explosives licensees, which the ATF oversees, and only 800 industry operations investigators, or IOIs. The Baltimore Field Division reports that there are 827 firearm dealers in Maryland, 148 in Delaware. They have 7 IOIs to monitor all of them. They physically cannot inspect these even every 3 years. When they find problems, they can do 3 things. They can issue a warning letter, they can mandate a conference, or they can revoke the license. That is it. They have no fining authority. In revocation cases, they may share the file with the criminal division to determine if any criminal charges apply. When they find problems that do not rise to the immediate level of revocation, they can't come back to inspect for at least 12 months by federal law. And none of this provides victims or communities any real redress when the ramifications of these violations have resulted in guns getting into the wrong hands. Unless you think that gun dealers are not the source point for crime guns, there are 9 Maryland firearm dealers operating today that have each been the source of 25 or more crime guns recovered over the last 3 years. The current regulatory and criminal justice system is not doing enough to provide oversight that is needed. We urge a favorable report.
Thank you very much. You may go ahead.
My name is Jen Poliakonis. I'm the Director of Policy and Programming at the Johns Hopkins Center for Gun Violence Solutions. The center supports House Bill 947. And I also do want to highlight written testimony submitted by Dr. Daniel Webster from my team, who has been studying this issue for many years. As you heard from many experts already, HB 947 is essentially a way to ensure that gun dealers follow responsible measures to prevent gun trafficking. Lack of oversight and accountability for gun dealers fuels illegal transfers and sales without background checks, and it circumvents the foundation of our gun laws. A study of ATF gun trafficking investigations found that illegal or grossly negligent practices by retail dealers accounted for more guns diverted to the underground market than any other single trafficking channel. And now it's a really small percentage of gun dealers we're talking about, but it accounts for the majority of guns recovered from crimes. This bill is going to impact that small percentage. Most gun dealers will not be affected by this legislation if they follow responsible and legal measures to prevent their firearms from falling into the wrong hands. The state has to have the ability to hold these few bad actors accountable. My colleagues at the Johns Hopkins Center for Gun Violence Solutions conducted a survey of individuals on parole and probation in Baltimore, found that 24% of those who had experience in the underground market knew of gun shops in Maryland where it was easy to get a gun without a background check or record keeping. My colleagues have also led studies showing that lawsuits against retailers led to significant reductions of guns diverted for criminal use in 3 cities. 24 dealers in New York City settled their lawsuit by agreeing to adopt a series of policies to prevent illegal sales and theft. These measures included simple things like requiring security cameras and strong inventory controls. Accordingly, the Johns Hopkins Center for Gun Violence Solutions respectfully requests a favorable committee.
And thank you very much. And you may proceed.
Good afternoon, members of the committee. My name is Kevin Sullivan. I'm an attorney at the law firm of Salisbury Sullivan in Baltimore, and I'm here on behalf of the Maryland Association for Justice to speak in support of House Bill 947. This bill, among other things, aims to hold the sellers of firearms responsible for selling a firearm to someone who should not have one. That seems like common sense. If we're going to entrust a private company to sell dangerous weapons, the most dangerous weapon available, we should insist that they do so responsibly. I currently represent the family of Jake Mace in a federal lawsuit against Walmart here in Baltimore. Jake was a Walmart employee suffering from an acute mental health crisis and suicidal ideation. His coworkers and managers at Walmart knew of the situation. In fact, Jake sent a text message to one of his coworkers telling about his plan to purchase a gun from Walmart to take his life. That text message was then forwarded to all members of Walmart management. And the employee who he shared the text message with went to management and pleaded with them, do something to make sure you don't sell Jake a gun. Put him on a blacklist. Tell other management, don't let this kid have a gun because he's going to kill himself. Management said, I'll take care of it. And a week later, nothing happened. Jake was sold a gun and he took his life in the parking lot. Jake was married with a young son and one on the way when he died. House Bill 947 would help ensure that other families don't have to suffer like the Mace family did. The proposed law also allows for punitive damages, which is important because punitive damage is what's going to make large companies like Walmart or other large companies with lots of resources take notice and make changes in their policies on gun law. Gun violence is very real. The experts all agree that firearms are the most effective forms of lethal means. I am a father of 3 girls going through the Maryland public school system, and this is very real to me. We need to do whatever we can to ensure that our children and our citizens are safe. For these reasons, I urge the committee to adopt a favorable report on House Bill 947. Thank you.
Are there questions for the panel? All right, seeing none, thank you very much. That concludes those testifying in favor of the legislation. We're going to go now to those opposed. Donna Worthy, Mark Schneider, Taylor McKee, Kathy Wright, Frank Boston. Mr. Boston, I also see Mr. Plowd is here. Is it both of you or one of you? Is it just one of you? Mr.
Yeah,
Plowd?
just
the one.
just
All right.
one of
So
us,
I'm gonna malice, scratch off Ari Plowd. We will not hear from him.
Yes.
You start from my right, your left, and move across. That would be fine. Thank you.
Good afternoon. My name is Donna Worthy. I'm president of the Maryland Firearms Dealer Association, as well as president of Worth a Shot, a firearm store in Millersville, Maryland. I strongly oppose HB 947. This bill is written with impossible standards for firearm stores. The bill is so vague, and it implies an impossible standard for owners to follow. Because of the vagueness of this law and the potential of lawsuits being essentially limitless, no company would be able to obtain insurance to cover themselves. Without insurance, companies would be forced to go out of business. This bill uses words such as reasonable and unreasonable. The use of these words leaves the bill up for interpretation. If the purpose of this bill is to reduce the amount of firearms in Maryland or reduce crime, this bill will not achieve that. This bill would, however, cause many gun stores in Maryland to go out of business. This bill will cause the loss of thousands of jobs and a large loss in tax revenue for the state. Individuals that wish to purchase firearms can still do so, even if a large number of stores go out of business. It is perfectly legal to purchase long guns in other states, and handguns can be purchased out of state by simply transferring said firearm to one of the few remaining stores in Maryland. Firearm stores are your first line of defense. We turn away any suspicious sales or straw purchases. We are already held to tight standards both by the state and the ATF. We have regular inspections and audits from both agencies. In conclusion, passing this bill would not reduce gun violence, crime, or even the number of firearms in the state. It would, however, reduce jobs and tax revenue for the state and cause many stores to go out of business. I urge an unfavorable report.
My name is Mark Schneider. I'm the Vice President of the Maryland Licensed Firearm Dealers Association and Atlantic Guns. Our organization takes issue with this bill. The presumption that licensed firearm dealers harm the public through the legal sale of highly regulated and constitutionally protected products is untrue. Our organization opposes HB 947. Data does not support the claim that Maryland licensed firearms dealers are the source of the reckless and illegal actions of criminals. We are a highly regulated industry abiding by both federal and state statutes governing the sale of our products. Licensed dealers do not sell to the criminal market. As you know, there are severe criminal and civil penalties for doing so. Vague terms such as reasonable controls and unreasonable under the totality of the circumstances are not defined or clearly explained and are thus unacceptable terms. If we don't know how to follow this bill or what it means, how do you expect us to be in compliance? Due to the vague terms in this bill, it would open every licensed dealer to frivolous punitive litigation. It would make it impossible to obtain insurance. We need to stay in business. Licensed dealers should not be held liable for the legal and lawful sale of firearms to law-abiding citizens. Those who commit illegal acts with firearms should. And we support stricter penalties for those who illegally use firearms. I request an unfavorable report.
Mr. Chairman, members of the committee, I'm Frank Boston III. I'm here on behalf of my two clients to the left, the Maryland Licensed Firearms Dealers, and we respectfully oppose this bill. You've heard their testimony, and just to make a clear example for you, if I am a gun shop and I sell a gun to Frank Conway, and who's a legitimate law-abiding citizen who purchased a gun at the Delegate Frank Conway, who purchased a gun at my shop. 3 years later, in his car gets broken into and the gun gets stolen. 2 years later, the gun gets used in a crime. How should I be responsible for that? Why should I be able to be strictly liable for that? Under this bill, that's how that scenario plays out. And you talk about fairness, and that's totally unfair. If you really think about the unintended consequences and the good actors and the good responsible licensed firearms dealers who try to do the right thing, this bill takes away all incentives. So with that, we ask for an unfavorable, please.
Mr. Chairman, members of this committee, Taylor McKee with the National Rifle Association, we're opposed to this legislation. It undermines the intent of PLCA and would subject all firearm industry members to frivolous lawsuits and increase legal costs, putting Maryland firearm industry members and those outside of Maryland's jurisdiction at a disadvantage. This bill is unconstitutionally vague and makes it impossible to comply with without subjecting oneself for future litigation. The terms like reasonable controls, unreasonable conduct under the totality of the circumstances are not properly laid out. They are way too vague. There is no definition for these terms. PLCA was enacted because of suits like these proposed under this bill, and when it was brought before Congress and before its enactment, it said that industry members were not subject to actions due to the harm caused by those who were criminally or unlawfully misused their products, and this bill seeks to do exactly that. Additionally, PLCA is not an all-encompassing blanket for the industry. Rather, industry members may still be subject to legal action if they create and introduce into the marketplace a defective product that causes harm or damage to someone. The other victims of this legislation will be Maryland residents and its small businesses and the firearm industry located within Maryland. It would increase the costs that would have to be passed on to the customers, and it would disproportionately affect the poorest among us and reduce their ability to exercise their constitutional rights. This would drive businesses to relocate across state lines in an attempt to remove themselves from some of the risk associated with the vagueness of this legislation. For these reasons, the NRA opposes this bill. Thank you, Mr. Chair.
Thank you, Mr. Chair. Again, I'm Kathy Wright with the Maryland State Rifle and Pistol Association, and we oppose this bill. As Taylor just said, the Protection of Lawful Commerce in Arms Act, PLCA, allows legitimate victims their day in a court for cases involving defective firearms, breaches of contract, criminal behavior by a gun maker or seller, or the negligent entrustment of a firearm to an irresponsible person, period. I hope you're aware that last week a federal judge in California blocked California's Attorney General from enforcing a new law that allows residents, state and local governments to sue members of firearm industry that manufacture or sell abnormally dangerous guns. The judge found that the law interferes with interstate commerce by extending liability beyond California's borders. Maryland, I hope you're listening. Maryland's licensed firearm dealers are not the bad eggs that has been implied today in the testimony in support of this legislation. Please see the Office of Attorney General's Maryland Firearm Crime Injuries, Fatalities, and Crime Firearms Study report, and I included that in my written testimony. It shows that the 15 top Maryland retailers of recovered firearms were audited and everything came out fine. They are not the source of crime. The manufacture and distribution and sales of firearm, ammunition, and accessories associated with hunting and shooting sports contribute to our economy, which was mentioned. There are hundreds of firearm-related businesses with good-paying jobs, which contribute millions of dollars to our state, including in conservation. You're going to drive them out of business, and it's going to hurt our entire state's economy. Thank you.
Thank you. We'll go to questions now and hear from Delegate Phillips.
Thank you, Mr. Chairman. First, I want to kind of go back and make sure I'm clear to my good friend as you talk about the potential for frivolous lawsuits. This is a reasonableness standard.
Mm-hmm.
And the gun industry, dealers, sellers, would you all say that you do have a set of standards that you operate under? Right?
Oh, yes, standards, regulations, rules,
Absolutely.
federal and state.
And so when a firm does not abide by those standards, I mean, really atrociously does not abide by those standards, that's when this might become effective. Is that unreasonable then?
Right, I mean, no one likes the bad actors. We don't want bad actors amongst us because it brings down the whole industry of the responsible players. You're a trial lawyer, I'm a trial lawyer.
I'm not a trial lawyer.
Well, reasonable standards, you're right. I mean, the reasonable standard is the correct standard. And I guess in a civil case, and I can't remember what the whether it's by preponderance in this or clear and convincing, but if it's by preponderance, I mean, we still have to. You heard my example. We're the law-abiding gun shop who followed all the rules, standards, and regulations. But now we got to go hire a lawyer that's going to cost us $10,000, $20,000, $30,000 to defend ourselves on a chain of custody of a gun that it maybe gets used in a crime, or maybe it's it has some other illegal use that we had no control of because we sold it to the law-abiding citizen. But now, even under reasonable standard, clear and convincing, hopefully not on the beyond the reasonable doubt standard, hopefully not criminal. We still have to go and defend ourselves when we did nothing wrong.
And so let me ask this: 10 states. You talked about increased cost. I'm not aware of any factual information that suggests in New York, Delaware, New Jersey, California, Hawaii, Washington, Illinois, or Colorado that there are a reduction in the number of gun sellers. Anybody can tell me that factually?
The only thing that I can tell you factually is that I forwarded parts of this bill to my insurance company, and they said there is no policy that they could cover for that wording of the bill.
All right, but once again, it was a conversation that there would be a reduction.
Without insurance, we could not stay open.
Okay, all right. And then when we go down this line of thinking, right, in terms of reasonableness and this potential significant impact to the industry, are you all defending bad actors?
Of course not.
Never.
And so the idea of holding bad actors accountable, you see that as a viable concept, correct?
They're already liable. If they get audited all the time by the state and the federal government, and if it's found that they've done wrongdoing, they can be criminally prosecuted for it.
That doesn't address this idea that maybe we don't have well, I'll just leave it at that. Thank you, Mr. Chair.
Yeah. Thank you for the question.
Mr. Boston, you said that this was a strict liability crime, or not crime, but strict liability action. How is it a strict liability action?
My understanding of the bill is, and I don't have a copy in front of me, is, everyone in the chain of custody is able to be sued.
Is that, I'm a simple country criminal lawyer. That doesn't sound like what a strict liability standard is. I think the strict liability standard is,
well, everyone can be sued and everybody's strictly liable. That's what the standard is. Yeah.
Okay. Are there other questions for this panel? All right. Seeing none, thank you very much. We'll move on to the next panel. John Jocelyn, John Hines, Mark Pennock, John Pica, Carla Mooney.
There you go. Mr. Chairman. Okay, thank you, Mr. Chairman. So, Mr. Chairman, this would hold a manufacturer, dealer, or seller strictly liable. Strict liability imposes liability on a defendant irrespective of their intentions. So if Ford were to sell a vehicle and the engine blew up and they knew or should have known of that negligent act, the negligent action would be if they knew or should have known. A strict liability action would impose liability on a defendant, whether they knew or not, whether they're irrespective of their intentions. So if they knew of the danger or should have known, they're going to be held strictly liable. Under tort law, this is not tort law. So there were a couple of examples. Let's just, and they use a delegate's name. So I'm not going to use a delegate's name, but if Delegate John Doe, instead of his firearm getting stolen, if he were to shoot his wife, that defendant, that person harmed, could sue a manufacturer. How would the manufacturer know what John Doe's intentions are when they buys a pistol or buys a firearm? It's impossible. This bill is indefensible. It's unconstitutional. It's unfair. Other than that, it's still a bad bill. This bill has been defeated several years in a row, Mr. Chairman. I hope it meets its same fate this year. Thank you, sir.
I'm Mark Pennick. I'm president of Maryland Show Issue. You have in front of you my 19 pages of single-space legal analysis of this bill that took many hours to prepare. And it details all the problems with this bill. And they range from unconstitutionally vague to a violation, clear violations of PLACA, to violations of the Commerce Clause. And indeed, it extends the state's jurisdiction beyond its borders in violation of the state's long-arm statute under due process. But let me focus just on the PLACA. The predicate exception, you've heard discussions about that. And it's important to read what it says. Predicate exception allows an action in which the manufacturer or seller of a qualified product knowingly violates a state or federal statute applicable to the sale or marketing of the product, and the violation was a proximate cause of the harm for which the relief is sought. That is the predicate statute. And if it doesn't fall into that, it's barred, it's preempted. That's a knowing violation of an existing law. That doesn't mean a foreseeable violation. It doesn't mean a foreseeable harm. Indeed, we don't even have to guess at what proximate cause means in this case, because we have established Maryland law on proximate causation. And I refer you to the Valentine versus On Target cases cited in my written testimony, in which the court held, our highest court in Maryland, held that a person who was harmed because a firearm was stolen from a negligently maintained dealer who allowed it to be displayed in a case where it was broken and stolen, that dealer did not owe a duty of care to the entire population, and the person who was harmed by the criminal misuse of that was not, could not sue the dealer because of the absence of proximate cause, no matter even if it was foreseeable. That's controlling proximate causation, and you don't get to abolish that because it's incorporated into the preemption provisions of PLACA itself. So I'm happy to answer any questions. I urge an unfavorable report.
Oh, I got one. Thank you. Good afternoon. My name is Carla Mooney. I'm from the 29C district. Again, I've come here representing Women for Gun Rights and the Armed Women of America in the state of Maryland. I believe this bill entered into consideration is missing the mark. Firearms are a self-defense tool of last resort, meaning that there was no other way to protect yourself or your loved ones for great bodily harm or death. With crime rising in our states, the need for more individuals to be able to protect themselves and their loved ones has also risen. The safety of oneself is certainly a right, is it not? I believe it is. The scripture from the Bible speaks to this issue, and I'd like to remind you, Mark 7:20-23, he went on, meaning Jesus. What comes out of a person is what defiles them, for it is from within, out of a person's heart that evil thoughts, come sexual, immoral, theft, murder, adultery, greed, malice, deceit, lewdness, envy, slander, arrogance, and folly. All of these evils come from inside and defile a person. Please consider that you're trying to legislate out evil in people, not manufacturers or retailers. I do oppose this bill and I ask for unfavorable report.
Thank you, Mr. Chairman. John Jocelyn speaking for 2A Maryland. Trace data is not indication of wrongdoing. You heard testimony that a small number of dealers are responsible for most of the crime guns. I would point you towards the Attorney General's own study that was commissioned as a result of legislation passed here, the chairman's own bills in 2020 and 2021, the Maryland Firearm Crime Injuries, Fatalities, and Crime Firearms Studies. I have sent these to you in previous testimonies. I will send it again. That document proves that the top 10 dealers that they identified each year for gun traces for firearm related crimes, they were not culpable. Their audits came up clean. There were no recommendations, no issues found. This bill reaches so far that it says that a firearm related product is an ammunition, so forth, or a firearm accessory. An accessory is something to be attached onto the firearm, and a firearm industry member is someone who distributes those. This is a firearm accessory under the scope of the bill. It's a gun lock. This one came from the Baltimore County Police Department. Under the definitions in this bill, the Baltimore County Police Department is now a firearm industry member. This is an open bolt empty chamber indicator. We use them for safety during ceasefires. Has my club logo on it. As club president, I become a member of the firearms industry because we distribute and sell these to our members as a safety product. This bill is so broad, it covers so many things. It basically is trying to open hunting season on an industry that some people deem as unacceptable in their personal view. We shouldn't encourage this kind of this legally empowered harassment of a law-abiding industry that is heavily, heavily regulated. We ask for an unfavorable.
Questions for the panel? All right, seeing none. Thank you very much. That concludes testimony for House Bill 947. We're going to move on to Delegate Buckle, is right there, House Bill 1126. And we have friends from ECM again who snuck in. Oh, you're back. They're so quiet. All right, well, there's only one person to testify in this case, testify on this bill.
Yes, Your Honor.
And it's Delegate Buckle.
Thank you.
Without objection.
Thank you, Mr. Chairman. This bill does not involve guns, although I'd be happy to discuss the restatement second of torts with you from what I just heard from the testimony that I've been in the room. This bill actually does touch upon a tort. I think you were probably right about what strict liability is and is not. But what this bill does, it does involve a tort concept, which is nuisance. And I'll try to quickly tell you why I brought this bill. In between over about a 9-month period between 2017 and 2018, a major railroad carrier that operates throughout our state, and it has its largest operation point in Baltimore City. Its second largest operation point is in Cumberland, Maryland, where I live. It had its trains hit 3 bridges. And when I say bridges, I really mean roads throughout the west side of Cumberland's primary residential neighborhoods. Over a 9-month period, the trains hit 3 bridges in sequence. The bridges run parallel to each other. The roads run parallel to each other. Those bridges were each completely disabled. They were required by state and federal safety authorities. You could not drive upon them anymore. You cannot utilize them as public roads. Your ambulances, your fire trucks cannot traverse them to go to a fairly dense and fairly large residential section of the city of Cumberland, which has a population of around 20,000 people. It's not a major city. It's not a small town. It's an urban environment. That was 6.5 years ago. I can't drive across any one of those three bridges today because none of them have been repaired at all. The common carrier who destroyed or at least disabled those three bridges and roads, there does not appear to be a means of redress under all of the varying levels of federal regulatory law and state regulatory law to require in a prompt and efficient fashion the rebuilding or the restoring of those bridges to use. It is a public safety nightmare. I would submit to you that if it occurred in your town, your city, your district, it wouldn't happen. This wouldn't happen. People would be up in arms, and people where I live are up in arms. That is the genesis of the bill. What the bill does is it creates an action for public nuisance, for an ongoing public nuisance for those common carriers that cause this type of damage to public infrastructure, roads or bridges in particular. And it requires them, or it allows either the state or federal government, depending upon who the rightful owner or operator of the public infrastructure is, to be able to pursue that common carrier on the ongoing nuisance theory, to force them to pay for restoration of the public infrastructure so that it can be used in its intended fashion, and can impose a fine, a daily fine, if indeed the common carrier does not do so. I am a very pro-business legislator. I have a lot of support for this particular business. It's a big business in our state. It's an important business. But when you hit somebody's road and they can't drive for 6 years, people can't get to their houses, the ambulance can't get there. If someone had a heart attack, you have to circuitously drive through an entire section of town from one road to the other because the roads won't connect because you can't cross any of the bridges back to back to back. That's not right. There has to be a solution to that, and this bill is intended to try to spur that discussion. Thank you.
Thank you, Delegate. We have questions. Delegate Cardin, Delegate David Fraser Hidalgo.
Everybody's on the edge of their seat wondering.
Yes.
Who was the carrier that did this?
It's CSX Transportation.
So CSX smashed 3 of your bridges 6 years ago and have done nothing to repair the bridges. Were they held at fault
I wouldn't
for
say
this?
they've done nothing. 2 of the bridges, they have engaged in a process, a federal process to come up with a bridge repair plan. They're not repaired. You can traverse traffic in about 2 years ago. They opened 1 lane on 1 bridge. One of the primary bridges, the Washington Street Bridge. I don't know how many of you have been to Cumberland. Washington Street is literally one of the most beautiful streets in the state of Maryland. It's one of the oldest streets in the state of Maryland. A former governor of the state of Maryland had a mansion home there. It is a beautiful street. My law office happens to be at one end of it, not where the bridges are, not distance from that. That has never been opened. You cannot traverse Washington Street, which is a main thoroughfare through the west side of the city of Cumberland, for over 7 years because the bridge was hit and destabilized.
Okay, so you're saying CSX smashed 3 of your bridges and they haven't really fixed them or done anything substantive to fix them. I just want to make sure we're clear. That's
Yeah,
what you're saying.
they are not fixed, and it appears to be a ridiculous situation of foot dragging. There are plans. Our city engineer has said one of the bridges, if you receive some federal funding to do it, they might be able to start repairing it in 2026, which at that point in time would be almost 9 years since it was disabled in this incident.
Why do they need federal funding to fix the bridge?
Because the city of Cumberland is very poor. And so, well, that's right.
Okay.
So that's right. So this bill would create a mechanism to force CSX through the legal process to pay the costs. CSX basically has denied that they're going to pay the costs. They have agreed under an agreement with the federal government to put a portion toward the costs. 9 years. I know people who for 9 years have had to drive 20 minutes, 15 minutes out of their way to get to their own house from exiting off of a highway exit, because it's one of those situations you can't get there from here. And it shouldn't be that way.
Thank you.
Thank you. Delegate Cardin.
Madam Chair, thank you for the bill. We all love trying to solve these problems. This is much easier problems than the previous ones we're dealing with.
Sure.
If it should happen, not in this case, but this would not just be for this one particular situation. This could be for a future situation, right?
Yes.
So if you had a situation where there was a bridge or there was a situation where there was a destruction of a road that might have been owned by either the municipality or privately owned by a HOA,
would they be able to go after as well, or is this only for the state and the feds?
It's for state and localities. I don't think that the bill would contemplate a privately owned road. I don't think it authorizes a private entity, although certainly if the committee believed that that made sense, I wouldn't be opposed to that. The way the bill was written, it would be a state or local entity that would be the proper plaintiff in action, because they would be the de facto owner or operator responsible for the road or the bridge in question.
All right.
Delegate Embry.
Thank you. And thank you for being here. So unlike the last bill, this does appear to be strict liability or very close to it. It's not a criticism, but am I correct in my characterization?
Well, I think it would include, it's not written in a way that it specifically talks about a negligence standard versus a strict liability. Strict liability normally applies to abnormally dangerous activities, things which cannot be made safe by the application of due care. Operating a railroad or a trucking company, I think, can be made safe by the application of due care. So if I was a court reading my own bill, I would probably imply that it would require some standard of negligence on the common carrier's behalf. I'd be happy to have that if you thought that it needed to be made clearer, but something. I'm not suggesting that if it's force majeure, an act of God, that, the operator of the train has a sudden heart attack and as a result, something occurs. But there are many, many situations where, simple negligence occurs. It happens every day. People are in car accidents. Sometimes people are in train accidents and other type of common carrier accidents. And these are the natural repercussions of it.
Thank you. And can I ask a follow-up, Madam Chair? So I appreciate that answer. What legal action did the Cumberland believe that they had available to them, and what were the limitations? I'm just trying to understand.
So I can tell you in this particular circumstance, and as Delegate Cardin pointed out, the bill's not a special bill. It would apply statewide. There's other situations where things similar to this have occurred: Howard Street tunnel collisions, problems, fires. But what happened in this case was because it happened in sequence, like it literally just occurred and then occurred again and occurred again. When it occurred the first time, everyone thinks, well, we can fix that road because you can get around it. It's the next road, the next bridge. Well, then the next two get taken out within a few months too. And now you can't go east-west at all. And so I believe what occurred was there was a lengthy period of disputation about who, quote unquote, owned the bridges because the CSX helped to frankly build a large section of the city of Cumberland and their predecessors, the B&O Railroad and other companies. And so there was a long period of time where there was a disputation about who owned the bridges, who owned the roads, if CSX owned them, did they have the ability to control them, et cetera, et cetera. And essentially, Cumberland and Allegheny County then engaged the National Transportation Safety Board, the federal regulatory authority. That process is a little bit like, pulling teeth. That will probably take you 20 years to get a ruling at a certain point in time. And now we sit here 6 to 7 years later, and they don't feel like they have any real options. It is an ongoing nuisance. So in nuisance law in general, as I'm sure you're aware, you can have a nuisance that is created and then it is abated and the statute of limitations begins to run from that point, or you can have a nuisance that is ongoing and continuing. It's never been abated or fixed. It continues to be a public nuisance with safety implications on a day-to-day basis. So the implication of the bill would be the statute of limitation would continue to run as long as the situation exists. Mm-hmm.
Delegate Schmidt.
Yes, thank you, Chair, and thank you, Delegate, for bringing this bill. I think you answered some of the questions regarding CSX. I know Baltimore City has similarities with CSX and who owns what, and
right.
Can you give me the specific situation where this occurred? Was it a long-term, or was it one instance where they hit the road, hit the bridge, or did it affect?
It was two separate instances about, I want to say 6 or 7 months apart. So the Washington Street Bridge is an extremely old street. There is a tunnel underpass. CSX has a very large operations center in Baltimore that ships to the city of Pittsburgh and points west, and then also diverts from Cumberland into West Virginia and hauls directly to the Port of Baltimore. It's a very large spot of entry for the Port of Baltimore. And so they hit the Washington Street Bridge and disabled it. The tunnel continues to go for another, 100, well, it goes for miles and miles, but several hundred feet away, there are other streets that run parallel with similar bridges. And I want to say 6 to 7 months later, they took a train, I believe it was a double stack train, and it ran through the culverts and hit the first bridge, just kept on going, hit the second bridge, and destabilize. They're not, I don't want to create a picture for you that these bridges lie in ruins on the ground. They are there. They are physically there. They have just been destabilized by the nature of the collision, that the highway engineers will not certify them for cars to go across them, except for one lane. There's three bridges: Washington Street Bridge, the Fayette Street Bridge, and the Cumberland Street Bridge. There is only one of the bridges that is open to one direction of traffic. Everything else has been closed for over 6 years.
Delegate Simmons.
Thank you, and thank you, Delegate, for bringing this bill. This is, just listening to you talk, and I appreciate it because it is a serious matter and it is of great concern. Several months ago, I had the opportunity to visit the port. And while I was at the port, the trains was a big conversation about the fact of their routes into Baltimore being a port that they're coming all the way from Middle America.
Right.
And these trains and the speeds that they're running and the hours that they're running. So that is true. My question to you is, now that we know that is a problem and it will increase as a problem, is that a federal or a state mandate to fix?
So I think it's probably a mix. I don't profess to be an expert in transportation law, but what my understanding is there are certainly things with respect to safety requirements for trains that are traversing state lines in terms of speeds or different elements of the safety checkouts. They're done by the federal authorities, the railroad safety federal authorities. But I do believe there's a lot of room for state action, so to speak, with respect to the routes that we allow them to run. We're making sure that they're safe. We're making sure they're appropriate. I want CSX to succeed. I want them to be able to run tons and tons of traffic and volume from points west into the Port of Baltimore. It's good jobs for both Baltimore, for Cumberland, for the whole state. I'm not anti-CSX at all. I just think that when something like this occurs, there has to be a response. The response just can't be punt it down the road. Well, we got to talk to the feds. Well, it's going to cost money. Gee, I don't know. And, real people's lives and potentially real people's safety is impacted by this. And the bill is designed to spur that conversation of ways we could find a solution.
So, and the importance of this conversation really, to me, revolves around mass casualty, because you're talking about derailed trains and things that can take place. And we have happened throughout the United States with these type of things, collisions in the middle of the night and things of that nature. So with the double-decker trains and all these things that we're seeing, the expansion of the railroad when it comes to commercial travel, where do you see the federal government or the state doing to regulate this industry?
So I know that with respect to the number of workers essentially who ride, who monitor the trains, I come from a family that has a lot of people that have been in the railroad industry. I have two uncles, both of whom work for CSX in different capacities. I have tons of friends who work there. And again, I'm a big fan. Unlike many of my brethren, and I respect their position, we have the two-man crew bill frequently. That is now a Republican bipartisan idea at the federal level. J.D. Vance, senator from Ohio, after the East Palestine disaster last year, is sponsoring that. I typically always, frankly, because I'm from where I'm from, I know that you can't drive a freight train with one individual, because that one individual could fall asleep. That one individual could have a sudden medical emergency. That one individual could just not be paying attention. And freight trains can be very dangerous if not maintained correctly. But they're wonderful things, but you have to do it the right way. So I think those are things that we can be involved in regulating and addressing safety concerns.
Delegate Boucher.
Thank you, Madam Chair, and thank you, Delegate Buckle, for being here. I appreciate your activism on this. Maybe I missed or didn't understand it, or why is CSX not held negligently liable for this to repair the bridges?
So, I think the short answer for that is that their contention seemed to be that it was not their responsibility. The bridges, the roads, essentially they are bridges, but they were roads, were placed there over their right of way, essentially over their train right of way. And they have seemingly taken the position throughout that it's not really their problem. They're willing, with two of the three bridges, to work in conjunction with the federal government for a funding solution. They'll put some funding toward it. The third bridge, the Washington Street Bridge, there is no plan whatsoever. In fact, the only plan that was ever discussed, strangely, would involve knocking down, I think, 6 to 8 houses. These are very large, very nice houses. They're houses, if they were in, some of the more expensive parts of the state, would be $1 million homes where we live, or, maybe $400,000, $500,000 homes. And their contention was we have to knock all of them down because the bridge would have to be repaired to the modern standard, which involves elevating it a foot or so, as opposed to the standard at which it is operated as a roadway for over 100 years. That's not cost feasible. It just couldn't happen. You'd be taking these people's homes and knocking the whole half of the street down. And so that's what they've done. They've sort of delayed and said, it's not our fault. It's not our fault. It's not our fault. And I believe that what is occurring is an ongoing public nuisance within the concept of nuisance law.
I think they should hire a very good Allegheny County attorney.
Thank you.
You're very welcome.
Well, thank you very much. I didn't hear that one, but
Wait a
thank
minute,
you
I'm
very
not-
much.
What are you talking about? Thank you. Thank you, Madam Chair. I appreciate it.
Thank you very much. That concludes the hearing for House Bill 1126. We're gonna move on to Delegate Chisholm with House Bill 1316. Delegate Chisholm, welcome.
Thank you, Madam. Thank God you're here because I recognized you right away and I realized I was not really sitting in ENT
No, you're not.
talking about trains.
No, no. In fact, Delegate Chisholm, I think this may be your very first time in judiciary ever? No? Okay, you were here last year. Okay, well. Never mind. We usually do a nice little welcome and sing and all that, but.
Really?
Yeah.
Okay. Well, I've noticed that this is obviously not a gun bill. because
Yeah.
There's nobody out there.
Okay, whenever you're ready.
Thank you, Madam Chair, and members of the Judiciary Committee. For the record, I'm Delegate Brian Chisholm here to present HB 1316. This is a very narrowly focused bill aimed to help our active duty servicemen and women. In uncertain time of stress and transition, this bill simply creates an expedited process when they've been deployed back to their primary Maryland home and they have a tenant that is staying over their lease. The genesis of the bill really was brought about by one of my panel members who's going to give his we need to check on it.
Everything's okay. Can you please continue? Thank you.
And he'll give his testimony in a second. The bill aims to prevent these situations from being so stressful as they are when people are being sent back here on deployment or for other military service duties. I think we all agree that these men and women are selfless in what they do to provide us all with security. So I think this is just a very small step to try to help them in these very unique but unfortunate situations. The original draft called for a 30-day expedited hearing. However, I did have a nice conversation with Judge Morrissey, and he wasn't against the bill, I'll say that. But he did say he was very happy if we would move this to 45 days, it would be much more be much more beneficial to those guys. And he thought that the judiciary could handle it at 45 days. The bill clearly spells out that the active duty service member or spouse intends to occupy their residence within 30 days in response to military orders. The legislation provides a clear and transparent framework. Furthermore, as amended, this bill authorizes process servers to post notices if the sheriff's office cannot do within 10 days what is prescribed, presenting a practical solution. We have heard from our sheriff's offices that they're all overworked and overloaded and they can't really perform all of their duties and perform this sometimes in the prescribed 10 days. So we wanted to offer another outlet for the active duty servicemen and women to be able to engage with, to get this process done so that their families aren't looking for somewhere to live or couch hopping while they've been deployed back here. I believe it is imperative that we embrace the favorable environment for active duty service members to confidently invest in home ownership in this state and not be afraid that if they ever are deployed out and deployed back in, that they might be left out in the cold. I believe the bill is positive and a meaningful way to say thank you to those that sacrificed so much for all of us. With that, I ask for a favorable report and turn it over to my panel. Thank you, Madam Vice Chair.
Go ahead.
Good afternoon, members of the Judiciary Committee. My name is Michael Ash. For the record, my testimony does not reflect the views or opinions of the Navy or the DoD. In 2019, my wife and I rented our Maryland home of 5 years while away on orders. In 2021, we got orders back to Maryland starting in February 2022. Our tenant's second lease expired October 31st of 2021, and our property manager notified the tenant we would not be renewing. Thinking she'd honor her contract, my wife and daughter drove from Washington back to Maryland in mid-November. I was at sea at the time. The tenant didn't vacate. She requested a series of short extensions until receiving notice that the holdover court date was set for January 18th of the following year. She then made it clear she'd stay until then. We filed a motion to expedite the trial on November 17th, but that request was denied without explanation on December 3rd. The tenant didn't show up to court and abandoned the property the day of. Luckily, we didn't have to go through the eviction process, which could have added months. 4 months passed from the time the lease ended to the time we were able to move back in. We were extremely fortunate to have a friend willing to put us up for that time. If we hadn't, we would have likely been paying for a hotel or month-to-month rental without access to our personal property. I can't put into words the frustration, helplessness, anger, and abandonment we felt during the 2.5 months we waited for our court date. The government, to which my wife and I have spent our entire professional lives in service to, would not or could not do anything to help. Meanwhile, the county health department was threatening to fine us for trash accumulation on the property we weren't allowed to enter. My daughter spent her 4th birthday, Thanksgiving, Christmas, and New Year sleeping on a beanbag chair. So much of our time that could have been focused on our jobs and family were wasted talking to lawyers, our property manager, and making pleas to the Maryland judicial and legislative branches. The law needs to provide protection to renters and landlords alike. No one should have to wait 2.5 months to have a tenant holdover case heard when it's preventing them from moving back into their home. Thank you for your time. I request a favorable report for HB 1316.
Ms. Ledbetter, you can begin whenever you're ready.
Thank you. My name is Shannon Ledbetter. I live in Crofton, Maryland, and I'm here today in my capacity of, I'm the spouse of a retired Marine, and I'm here in support of HB 1316. During my husband's 20-year career, we moved an average of every 3 years. Moving that often is hard. The mental, emotional, physical, financial, and logistical challenges are very much a burden. As soon as a military family receives orders, an entire process begins. The spouse updates their resume, undertakes a new job search. The search for childcare in the new location begins. Insurance must be updated and changed. Utility services all transferred. Car insurance updated. The packing of household goods coordinated. The dates of your unit checkout have to line up with the dates of your move out, which needs to line up with your new home move in, which also needs to line up with your unit check-in. Your travel, often across country, sometimes unaccompanied by your military spouse member, must be planned. Children's school documentation, report cards, test results, possibly teacher recommendations, all has to be collected from the old school, and proof of residency must be collected for the new school. And goodbyes have to be said. You have to find ways to cope with the loss of friendships, support networks, lifestyles, communities, and spouses' careers. Now imagine doing all of this every 3 years. It's a hard lifestyle to live. I cannot calculate the additional stress placed on a military family who endures all of this and then cannot move back into their home because a tenant is holding over. However, I can calculate the financial impacts. Regardless of circumstances, the military member is only reimbursed for 10 days of temporary housing. The impact on military children is also tangible. In Anne Arundel County, to register for public school, you need to provide a recent utility or cable bill along with your mortgage statement to prove residency. If the military member cannot move into their home, they possibly could have their child's education adversely affected. HB 1316 is a very reasonable update to the eviction code that will protect military members from bearing an unreasonable burden during what is already a heavy lift. I respectfully ask for your favorable vote.
Thank you. Delegate Schmidt.
Yes, thank you, Chair. And I'm reviewing the bill here, Delegate. Thank you for bringing this forward. Any reference to the military community, or I know that we're both members of the Veterans Caucus. Anything here?
Yes, thank you, Delegate. So the Veterans Caucus looked at the bill and they gave us a letter in strong support, and so did the Maryland Military Coalition. We're both strongly in support of the bill.
And I know that we both know Brigadier General Sapp. Did he weighed in on this, or did you get a chance to talk to him? I know that he handles a lot of the Fort Meade.
Yeah, I don't know if he was in support, but I don't know if I got the letter in my file for it.
All right, thank you.
Delegate Crutchfield.
No problem. Well, thank you very much, Delegate Chisholm, for bringing this bill. And I'm sorry, Madam Chair, thank you. But anyway, thank you very much for bringing this bill. I am a surviving spouse of a military officer, and believe it or not, was in this same similar situation. And so I do support this bill, definitely, but I just have one question, and that is that you added in private detectives for service. Why did you make that change? I know you have the regular means of service to somebody, but you also have in private detectives.
First, thank you for your service. We spoke to the sheriff's office, and when talking about the eviction process, they were saying that all the sheriff's offices, including our own in Anne Arundel County, are kind of overwhelmed right now with workload and not having the capacity to be able to do it themselves. So speaking with Judge Morrissey, he said you might want to just add process servers instead, because they can obviously do the job as well and do it effectively, and hopefully to pick up some of the slack that the sheriff's office currently cannot do in a timely manner due to the constraints of workflow. Thank you.
Thank you. That concludes the testimony for House Bill 1316. Well, for this panel, we have one person testifying unfavorable via virtual technology. Okay, great. That concludes the test. Mr. Hill?
Yes, hi, I apologize. Thank you.
There. You can begin whenever you're ready.
Thank you. My name is Matt Hill. I'm an attorney at the Public Justice Center. Public Justice Center is a statewide organization that focuses on civil and human rights. We represent renters in a variety of eviction cases, and we also advocate alongside renters for laws that enforce safe, habitable, healthy housing. I appreciate the testimony and I appreciate the bill, and I sympathize with the plight that the proponents are talking about. We are opposed to the bill. Our primary opposition is around supplanting the central role of the sheriff that the sheriff plays in all service of eviction cases. It's usually what we call a nail and mail service as opposed to personal service. The sheriffs have been doing this for many years for all eviction cases, and it's generally required of the sheriffs in these eviction cases. So we're concerned that this could be a slippery slope to allow private process servers into other service of eviction cases. You know, the sheriff is a neutral party. They're accountable to the voters. And so we're, very interested in maintaining their position as the neutral arbiter of service in these cases. And I would be really interested to see if there's any data to suggest that sheriffs are having difficulty with serving these cases timely. I don't, at least in where we practice, I don't think that's an issue. Secondly, the requirement to have the trial within 30 days or maybe moving to 45 days is only a concern, I think, because at least from our client's perspective, they're being told they have to move as well, right? They've been given a certain notice to move their families within a certain period of time. And some of them may want to access their right to attorney in these cases. And so I wouldn't want that language to be interpreted as prohibiting them from getting a postponement in order to access their right. Thank you.
Thank you, Mr. Hill. Did you get a chance to finish? Was there anything else you wanted to elaborate on?
No, Madam Chair, thank you.
Okay, thank you very much. And I see no questions. So now that concludes the testimony for House Bill 1316. Thank you. We're going to move on to House Bill 1308. This is Delegate Weibel. Okay, Delegate Valentine will be hearing from him for House Bill 1308. Oh.
Thank you, Madam Chair. Good afternoon. Thank you, Madam Chair, members of the House Judiciary Committee. For the record, Delegate William Valentine, District 2A, representing Washington and Frederick counties. I'm before you today to present and request a favorable report on House Bill 1308, real property, recordation of instrument and false information. The impetus of this proposed legislation is from an experience of a resident of District 2A in Washington County. Delegate Weibel was contacted by this resident who had fought and ultimately won a court battle defending the title to his property. An individual had prepared a deed recording his interest in this real property over the deed of the rightful owner. The rightful owner, once discovering this false recording, spent $80,000 in court costs and attorney fees successfully defending the title to his real property. HB 1308 simply states that a person may not falsely record a deed or other instrument that a person knows contains false information. Doing so would result in a misdemeanor offense and carry a possibility of a fine not to exceed $500. HB 1308 also allows the court to award attorney fees to either party in defense of the claim in regards to a violation of this code section. Delegate Weibel and I would also like to present two amendments to the committee. The first is a simple amendment. This bill came before the committee last year as HB 845. It was agreed to be passed as a local bill. However, the amendment to do that was not received in time for this committee to act. Although we believe the recording of false deeds is a statewide issue, we are offering this amendment to make the bill applicable to Washington County only, if at the direction of this committee. The second amendment would remove Washington County from a section of 3104 of the Maryland Annotated Code, which lists the county as an exception in certain requirements before recording a deed, and we believe this would negate the recording of any such straw deeds in the future. So to summarize, this bill does the following. It removes Washington County from the exceptions for recording deeds. It prohibits and creates a misdemeanor offense for someone who records such a deed, and it allows for a recovery of reasonable attorney fees. I would ask for a favorable report on this bill, HB 1308. I thank you in advance for consideration for this bill. I would note that as it was not originally drafted as a local bill, a delegation letter of support is not in this file. However, Delegate Weibel and myself would work with our delegation to secure this documentation and provide it to the committee as soon as possible. Thank you.
Thank you, Delegate. Are there any questions? I have perhaps two. One question is, why do you want to make it a local bill? I mean, why do you want it to just be Washington County?
I'm going to speak for Delegate Weibel in this regard. That was the direction he had received last year under the previous bill that I noted in my testimony. And so he had actually submitted a request to have it made a local bill last year, but did not receive it back from the amendments office in time, and in fact killed the bill last year for not being able to get that back in time. And that was what was relayed to myself.
Okay. We've got questions now. Delegate Cardin.
Now, thank you for taking that time because I was just reading a little bit before I wanted to ask my question. Thank you for bringing the bill. I know that you're not the expert here. Maybe you can take this back.
Okay.
The bill prohibits a person from recording a deed or other instrument the person knows contains false information, including information related to the ownership of the property. Violation is the person is guilty of a misdemeanor subject to a penalty of $500, right?
Yes.
Okay. You're telling me that that's not already illegal. You can now file, you can record false deeds with false information presently. You could go to the Washington County Clerk's office and just go with a bunch of information and file a deed, record a deed on a piece of property that you don't own, that you have no.
I believe that's in fact what happened with the constituent that brought it to Delegate Weibel. That's what he went through.
Okay. And there's no remedy for him, you're saying, to be able to sue so you're turning, I mean, I guess it would be a civil matter and you're trying to turn it into a criminal matter. That the rightful owner of the property could sue this person for recording a deed that they falsely recorded. And you want to turn it into a criminal matter, or what's what Delegate Weibel wants to do?
A misdemeanor offense, yes.
Okay, now I think I understand. I think I got it. Thanks, Madam Chair.
You're very welcome. Delegate Schmidt.
Yes, thank you. Thank you, Madam Chair. I will highlight, this was brought to my attention from the clerk of court that Delegate Valentine was talking about. There's also situations in Anne Arundel County where the clerk of court has had similar issues as well. So to piggyback off what Delegate Cardin was saying, it strengthens, if you look at some of the testimony from the Maryland Realtors and some other, it strengthens the penalty for when this happens. But the clerk of court did reach out to me in his jurisdiction regarding this matter. If that helps.
Yes,
Delegate Valentine.
It does.
Actually, it supports why it shouldn't be just a local bill, but but thank you for your comment. Are there any other, isn't that so? Are there any other points?
And I will say that he did not originally draft it as a local bill. He was only going by direction, so.
I understand. Great. You did great. Thank you, Delegate Valentine. And that concludes our testimony for House Bill 1308. So we're going to move to our next bill. House Bill, you have another one. House Bill 1323. And Delegate Valentine will be presenting this bill as well. So, yes. Whenever you're ready.
Again, thank you. Good afternoon. Chairwoman Bartlett, members of the House Judiciary Committee. For the record, Delegate Valentine, District 2A, representing Washington and Frederick counties. I'm before you today to present and request a favorable report on House Bill 1323, Courts Immunity from Liability Maryland Safe Haven Program. This bill will assist in modernizing Maryland safe haven law. State legislators began enacting safe haven laws in 1999 to address infant abandonment and infanticide. Safe haven laws passed with bipartisan support and have been enacted throughout this country, including Maryland. The Maryland General Assembly enacted Maryland Safe Haven laws, establishing a program in 2002. These laws have proven to be an effective solution in preventing the wrongful and illegal harm and death to newborn infants. These laws serve as an alternative for mothers in crisis to safely relinquish their children or babies or infants at designated locations where they can be protected and provided with medical care until a permanent home is found. Safe haven laws generally allow a parent or an agent of the parent to remain anonymous and to be shielded from prosecution. Safe haven laws also provide important legal protections to the providers of designated facilities like hospitals and police stations. The Maryland Safe Haven Program is administered by the Maryland Department of Human Services, and according to reports from the department, the program is underutilized, with no new newborn saved through the program in the last few years. This bill seeks to modernize the current Maryland Safe Haven Program as related to the Maryland Safe Haven Program within existing budget appropriations and increase accessibility of the program by enacting the following enhancements. Increasing the time allowance under which a mother can safely relinquish her infant from 10 to 60 days. 2, the bill would clarify for regulatory purposes that a designated facility under the Safe Haven law includes a professional or volunteer fire company that is insured. 3, the bill would modernize the current Safe Haven law by allowing designated facilities to utilize a newborn safety device to provide women with a truly anonymous option. 4, the bill would provide additional guidance to the Department of Human Services in their efforts to educate and notify the public about the availability of this program. And finally, the bill would provide the General Assembly with an annual report from the department with measurable results of the Safe Haven program, including the number of infants safely surrendered each year and a final disposition related to child custody. Improving upon the work completed by the Maryland Safe Haven law, we can provide greater access to the program and reduce the risk of illegal abandonment of vulnerable infants in our state. And I respectfully request a favorable report on this bill, and it is Senate cross-filed under SB 873.
Thank you. And I see Mr. Jonathan Alexander coming up. Thank you very much. And if you are ready to testify, you may begin.
Certainly. Good afternoon, Madam Chair and members of the committee. My name is Jonathan Alexander. I'm an attorney and legislative counsel for the Maryland Family Institute, and we are in support of Maryland's Safe Haven program, as it really is the best of Maryland's hospitals, law enforcement, and charitable resources, a confluence of those best things directed towards really the best of us, which are the newborns in this state. Pregnancy is difficult, so I've heard. Child rearing can be a challenge, but the love of a parent for their child is truly unmatched. And parents who are unable to care for their children can find here in Maryland's Safe Haven program a liability-free, really a guilt-free way to ensure that their child would be cared for in their absence. My grandmother has 4 children, 10 of us grandchildren, and invariably the conversation comes up as to who is her favorite. And we all know what her answer is. Her favorite is Mara Luna, a baby that she heard crying and found in a trash heap. She raised Mara Luna, who is a graduate of college and now in diplomacy school. Maryland's Safe Haven program sees a mother and a child like Mara Luna desperate in that situation. It also sees the preciousness of a life that says that without judgment and without criticism and with some simple practical steps, this mother can release the care of her child in this high quality standards of the Safe Haven program that this bill lays out. It's heartening that it also adds the assistance of counselors to the mothers in crisis, where they can access the necessary resources that enable them to make decisions that prioritize the well-being of their babies. This is a feel-good bill, as it aligns with the best interests of Maryland's precious children. Therefore, we wholeheartedly recommend giving this bill a favorable report.
Thank you. Are there any questions? Okay, Delegate Kaufman.
Yes, and if you need to, it's good to see you, my friend. And if you need to take this back to Delegate Wyville, that's fine. Have you seen the letter of information from the American Academy of Pediatrics and the American College of Obstetrics and Gynecology, where they like the bill, but they say the newborn safety device, which reads as if it were some type of box that has certain capabilities to monitor the newborn. And then they go on to say, while the safety and legal surroundings of a newborn by a mother who does not want to, blah, 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 blah. There is no research or clinical evidence of the safety or appropriateness related to the device. And then they say, before advancing the legal framework provided in this bill, there should be clear and uncontroverted clinical evidence supporting the use of these devices. So can you elaborate a little bit about, if I'm Jane Doe and I drop my baby off because I can't care for the child, and so if I go to a fire department, or what device they're going to be in, and if you know about the safety?
The boxes he's referring to is the Safe Haven baby boxes, and some of the research from stakeholders and the delegate provided me said that these boxes have been in existence and been utilized since 2017. As far as the cost, as far as how this would be set up, it's my understanding from talking to the people involved that they would be through a private organization. They're not asking for state funding to be implementing this program at the locations. And as far as some of the regulatory information on the boxes, it was determined that the FDA does not approve these because it is not considered a quote medical device and does not require FDA approval. And one of the other statements was that it is not available for public sale to the public, or in that regard. So I hope that answers some of the questions.
So what could you just describe it a little bit? It's some sort of device that people place the baby into?
Yes, the device, and I don't want to, I'm trying to kind of explain it. It would be a locking, a device that would be affixed to a structure, okay, like a police station or a fire department, that would have a door that once something is placed in, it would be a self-locking mechanism that it would lock. It would be tied into the 911 system so that it would alert that someone has been placed in it, and it would be like a temperature controlled environment. It's not a quote incubator or anything like that, but just be a temporary location that would be secured and monitored so that it would alert authorities. And again, we're at these locations, we're at a fire department, we're at a police station. So it's literally affixed to that location, as that's how it was explained in the literature that's been provided to me, how it would work.
Okay, finally, and it's totally up to Delegate Wyville, but thank you for your indulgence, committee. Delegate Wyville may want to reach out to Pam Casemeyer, who wrote this letter, to inform her of all that. She represents the Academy of Pediatrics and the American College of Gynecologists and Obstetrics. All right, thanks.
Thank you, Delegate. I will relay that information.
Delegate Boucher.
Thank you, Madam Chair, and thank you, Delegate, for bringing this forward. You said it's being monitored. Is it under video surveillance? And the second part is, how many babies have we saved through this surrender process since its inception? Do you know?
As far as the literature I was provided was that it would be monitored like the inside, because again, it's the anonymity for the mother or the individual who's, so it would be inside the who's dropping off. That is the information that I was provided.
All right, thank you.
As far as the program, bear with me 1 second.
No problem.
I believe I have that number that you're inquiring about.
This is where we need the Jeopardy music. There we go. We got it going on over here.
I do not want to take up too much of your time.
Delegate Valentine, you're doing great. Take your time.
Now, I cannot, this is not specific to Maryland because this is nationwide. The figures I was provided was, so 206 boxes have 43 safe surrenders in 18 states since the program's authorization in these states. So I can't go back how far, but basically 43 safe surrenders utilizing this.
Thank you very much.
And there may be a nuance between this particular safe haven box and the safe haven laws that have been existent for 30 plus years.
Thank you. I see no further questions. Thank you very much for your testimony, and that concludes the testimony for House Bill 1323.
Thank you.
Tell Delegate Wyville we missed him. Okay, we're going to move on to Delegate Mangione. Oh, withdrawn. Okay, sorry, I didn't know that. So we'll move on to Delegate Embry. House Bill 41 was withdrawn. So we'll move on to Delegate Embry, House Bill 1258.
Thank you, Madam Chair. May the panel join me? Yes. Madam Chair, thank you. And I believe the final member of our panel is in the waiting room or
okay,
available
so
to speak remotely.
So Mary Roll and Brian McFarland. And so with you, you have Laura Thomas and Alexis Barrow Road. Is that correct?
Yes.
Okay. All right, Delegate, whenever you're ready, you may begin.
Thank you, Madam Chair. Thank you, members of this committee. I am proud to bring you another bill that is unopposed. This also not only does not cost money, it will save our constituents a great deal of money during the probate process. Historically, in the probate process, we require notice to be provided to people who might not have known of the death, creditors potentially, or heirs who weren't aware of what happened. These are people who are not notified by letter. These are the unknown interested parties. And so we require currently that notice be placed in newspapers of general circulation, because that was traditionally the way that we all received information. But no, that is no longer true. And the problems with it, which will be detailed by the witnesses, are that one, there are fewer and fewer newspapers. So that's a problem. I mean, that reach the people who need to be reached. We have the option of an online database, which currently exists and is extremely successful, and I think is a better way of reaching people. The newspapers charged have complicated billing structures, and it's sort of a monopoly in some counties because there's only one newspaper, and so they're charging, and it's not just the state, they're charging the heirs, the people, the personal representatives, a large amount of money. And they have no other options. And again, processes that are problematic for not only the family members, but also for the courts. And I think this is just a matter of good government. This, I think, is better for the state and for all people involved. And it also has the benefit of saving money. And the registrars have been proactive, and they have a website, which they will describe how effective that is. So with that, I will turn it over to them. Thank you.
Thanks. Should I go? Okay. Hi, thank you, Madam Chair, and thank you, Delegate Embry, for sponsoring this legislation. My name is Alexis Burrell-Rohde. I'm the Register of Wills for Baltimore County, and I'm here to testify in favor of House Bill 1258. And the reason I came down to Annapolis to testify in favor of this is that this bill really just makes a lot of sense. Right now, Marylanders spend $1.7 million per year publishing legal notices. And the intent behind the legal notice is to give notice, as Delegate Embry said, to unknown heirs and also creditors that may not have received an actual mailed notice when the estate is opened. The problem with this is it's not money well spent because the intended audience don't typically look in the Daily Record where we publish in Baltimore County or some of the other newspapers in other jurisdictions. So they actually don't receive the notice. And a better way to do it is for the notices to appear for free on the Register of Wills website, and they have been published on that website since March of 2020. And since that time, we have gotten on average 9,000 of views per month on our Register of Wills website. And the great thing about it is you can put in Maryland estate search into a Google search and our website comes right up. It's not behind a paywall, and the information is accurate and current. We have some of the registers in other jurisdictions have repeated problems with the accuracy of notices, that some of the newspapers that they're published in are in out of state and they can be very expensive. The Daily Record is $113, but that fee, which isn't terribly expensive, but considering that the notice in the newspaper doesn't read its intended audience, not money well spent. Thank you.
Madam Chairwoman, thank you for having me today. My name is Laura Thomas, and I'm here on behalf of the Estate and Trust Law section of the Maryland State Bar Association. And the Estate and Trust Law section is here to show its support for House Bill 1258. In private practice, we see a couple of common occurrences that happen with the publication of notice that we believe that this legislation addresses. The first is the cost of the publication in the newspaper. The fee can cost hundreds of dollars. And in addition, most counties have only one newspaper that qualifies under Maryland law as a newspaper of general circulation, which eliminates competition in the free market to keep prices low for Marylanders who need to advertise that an estate has been open. The second problem is the decreasing reliance on the general public on newspapers. The purpose of the newspaper notice was to reach as many people as possible in the area and to render it probable that the notices would be brought to the attention of the general public. That's not the case anymore. The place that people go for their information is the internet, and putting those notices online, not behind a paywall, is advantageous to our clients as a whole. The third problem is a lack of consistency among the Register of Wills offices based on the restrictions placed on them by the newspapers. In some counties, we have to send payment directly to the register when we open an estate, and then the register has to send it on to the newspaper, versus other counties, the personal representative and the estate get billed directly. So we believe that this legislation solves the problem by centralizing the database, providing it at no cost, and allowing for consistent treatment amongst the counties of the state.
Thank you. We're gonna move on to Mary Roll now online.
Thank you so much. Good evening, or good afternoon, everyone. I'm Mary Raleigh, the Register of Wills of Frederick County, and I am in favor of House Bill 1258. Frederick, the only newspaper that we publish in is Frederick County News Post. That's the only one in the county. It is now owned by a company in West Virginia. We are the most expensive when it comes to publication. To publish for a small estate now is $128. To publish for a regular estate is $343. And I believe the neighboring county is only $50. So it's very, very expensive. And the other issue we have are the problems with the errors. We actually, we've been keeping track of them. And from July till last week, we've counted almost 100 mistakes. And we have a staff member that every single morning, anywhere from 1 to 3 hours, has to look at every single publication and make sure that is done correctly. Then she needs to contact the newspaper. The amount of time that it takes, where this person could be doing the work, working with families that have lost loved ones, and we're all of a sudden taking care of the newspaper. But what really bothers me is the amount of money that we are charging. Thank you.
Mr. McFarland, please, for 2 minutes.
Great. Well, good afternoon or good evening, Mr. Chairman, members of the committee. My name is Byron McFarland. I am the Register of Wills for Howard County. I chair the Legislative Committee of the Maryland Register of Wills Association and am here to testify in favor of this bill as well. I want to thank Delegate Embry and my colleagues for their support, and I really just want to echo a lot of what has already been said. I don't want to belabor anything, but I do just want to bring your attention to, in my written testimony, if anyone is interested in looking at an estimated breakdown of what this costs your constituents in your county and your jurisdiction, that is part of my testimony. If anyone wants to see a copy of the notice that we actually give out to the public that we directly mail to interested persons, that's also part of my testimony. And as I just want to echo what my counterparts have said, which is that this really is a burden on our constituents. It's superfluous. We know that people are using our website heavily. Again, it's been up and running for almost 4 years, which is great. We've seen the traffic steadily increase. One of the beauty parts of our system, as opposed to the newspaper system, is, as my colleague from Frederick County said, when there are errors, we have to contact the newspaper. We have to get them to print a new notice. That delays the entire estate process and takes us time and effort as well. So we have to wait days, weeks, and sometimes even months for a new notice to be published. If we find an error on our online system, we can fix it instantly. So it really is a terrific tool. I can speak more to the technical side of some of this if anyone's interested, but I appreciate the committee's time and urge a favorable report. Thank you.
Questions for the panel? Delegate Taylor.
Mr. Chair, this is one of those things where I say, why didn't I think of that? So, oh, sorry, I do this all the time. This is great, right? But, me thinking about it as an inventor of sorts. Have you thought about maybe broadening the scope? Because technology is changing so fast, right? So maybe to say something like broadening to read or other approved media. So it was on my screen, I promise you, but it's not here now. So I had it right here. But in that section where it says centralized website or approved media or something like that, I don't know. And then I was thinking, could we have this work almost in a reverse? So I could opt in to this website, like it would have an opt-in feature where, Kim Taylor would say, okay, if you ever need to find me, I'm opting in, so it'd be easier for you to find me. That's all. Is that a question? Have you ever considered those things, I guess is a question.
I think this is probably best for Byron to address on the technical side.
Delegate Taylor, the second part of it, we had, it's a great question, and I think you're actually sort of jumping the gun to where we are going to be going in a few years, which is when we are going to be implementing an e-filing system. And this publication part, we have some things that we're doing as a collective statewide right now to get us to that point. We actually have rules before the Rules Committee of the Judiciary presently on implementing an e-filing system, so that, you know, if you're an attorney, at least you would be able to create an account through our system that would make it easier for us to locate you and communicate with you. And as far as your first point, we're not wedded to any particular language. So if you are interested in broadening it, I don't want to speak for Delegate Embry, but if you are interested in broadening that to not just a website, but other media, I think that we would be open to that as well.
Can we talk about, is that all right if we can talk about it? I think it's very interesting. Thank you.
Chair, thank you for bringing the bill. Alexis, always good to see you.
Yeah, good to see you.
So first of all, what's the daily record and the other publications they're obviously they didn't come out opposed to this. But I mean, I think the writing's on the wall that eventually these guys are all going out of business because this is their major source of revenue, right?
They are not here today and they did not.
I mean, maybe they're not, and maybe they're not here because they just don't have the staff to be able to come here and do this. So I think that these publications are like seeing the writing on the wall.
Well, I mean, I just to address that a little bit, where I do feel like I love a newspaper and a daily newspaper, and the Daily Record is a long-standing legal newspaper, but it has never really been one that the average person got on their doorstep on a Sunday, because it covers legal news, court cases and that sort of thing. So while it qualifies as a newspaper of general circulation, I don't think your average person who lost a family member, was an estranged child of a family member, was pulling that out to look at the legal notices. So that's one issue with that, and trying to sort of explain what the Maryland Daily Record is. In terms of the legal notices, I do know that they are pretty critical to some newspapers' business plan. In Baltimore County, the Jeffersonian, which had been around forever, recently stopped doing legal notices on its own. So we have fewer newspapers now in Baltimore County to publish legal notices. And while I'm sympathetic to that cause, I don't think that the population of the state should be keeping these papers afloat. Yeah.
Just one last thing is there thought to the long-term strategy for exposing people to this information through your website, and how you're going to strategize and budget that, so that just like the comptroller does with unclaimed property, pretty good at sending out information and letting people know.
And I think that that's something that I'm particularly interested in. I know I've spoken to Byron about how to elevate Google searches. So if you put in a decedent's name, would the legal notice pop up right behind the obituary from the legacy?
Great.
You know, like we are in favor of that and would like to get as much exposure as we can. I can tell you right now, if you're trying to search a death notice and you put in the Google search bar Maryland death notices, our website is the top result when you do that. In terms of expanding that and expanding access through a less specific Google search, we are definitely in favor of that and are looking at ways to make sure that those search results are elevated.
Thank you. Thank you.
Further questions? Oh, that's right. Delegate Kaufman, go ahead.
Yes, my question is, first of all, I'm going to support the bill, Delegate Embry. It's a great bill, but I'm just using my grandma as an example. My grandma didn't have a computer or internet or anything like that. It wasn't because of poverty. It was because it was too intimidating for her to learn how to do work the computer and the internet. And then I had a friend in high school who, because of poverty, didn't have a computer or internet at home, so he typed all of his papers in the media center. So my question is, I support the bill, but what are you going to do to mitigate the impact on those who are still suffering from the digital divide, because that's so real, and may not have a computer, and they may go to the Baltimore County Library, but have to wait an hour to get a 30 minutes on the library computer. So what are you going to do to mitigate the impact on those who do not have a computer or internet access?
That's a really good question, and we are sensitive to those issues. Obviously, you mentioned the library. They also would be available on your iPhone, a smartphone. If you don't have either a home computer, you don't want to make it to the library, you could always come into any register of wills brick and mortar office location and search legal notices from one of our public terminals. You could also, I guess, if you knew to call an office, you could call an office and speak to one of our deputies in the office, and we could search legal notices on your behalf. Those are the ways that I think that would be addressed. Very few people really ever got, unless you're in the legal industry, really subscribe to the Daily Record, which is the Baltimore County paper. And those were available at the library as well. So it would be switching from the hard copy paper at the library, if you didn't have a computer, to using one of the public terminals.
I think that as part of your outreach campaign, you might want to tell people about some alternatives if they're not fortunate enough to have computer or internet access, like you outlined today.
It's a really good, thank you. That's a really thoughtful question. I appreciate it.
Seeing no further questions, thank you all very much. And that completes the testimony on House Bill 1258.
Thank you.
I am informed
you.
that there are several pages in the audience, and so now we will torture them and ask them to come up to the witness table while the next people get ready to go. The pages would please come forward to the table. Oh, everyone, they appear to be wearing red badges, which means that they were in the Senate. It's somewhat disappointing. If you would just say your names for the record and let us know where you live. Not exactly, but your county where you live.
I'm Scott Pauly. I'm from District 30 in Anne Arundel County.
I'm sorry. I'm Demi Fidayo and I'm from District 43B, Baltimore County.
And I'm Abhishek Iyer. I'm from District 9B, Howard County.
The last time we asked questions to the pages, it took way too long and it started to get too entertaining for the rest of us. And we have a couple more bills, but we just wanted to welcome you to the Judiciary Committee. Thank you for spending a couple minutes with us, and we certainly hope you're getting something out of it today. Thank you very, very much.
Thank you for having us.
All right. We move favorable. Delegate, do you need time? Okay, you're requiring me to. One moment, please. Okay, I think the next bill we need for Delegate Valentine, I think we need Anderson Aldridge, please, to come to the front. Mr. Aldridge, is it true that it is possible that you are working as an intern this session for someone who's on the committee?
Yes, sir, it is.
And who are you working for?
Working for Delegate Valentine.
Oh. Are you here to help him on this next bill, or does he need any help on this next bill? Oh, yeah, just think about it. Delegate Valentine, thank you very much. Thank you very, very much for coming up here. House Bill 316, Delegate Valentine. I've killed enough time now with the torture chamber for interns and pages, apparently. Delegate Valentine, the sole witness on 316. Go ahead.
Thank you, Mr. Chair. Okay. Good evening. Thank you, Mr. Chair, members of the, Madam Vice Chair and members of the House Judiciary Committee. For the record, Delegate William Valentine, District 2A, representing Washington and Frederick County. I'm before the House Judiciary Committee today to present House Bill 316, Violent Firearms Offender Act of 2024. This bill and those in a similar posture have been introduced on years previously, most recently passing the Senate in 2021. This is in addition to many bills that we've heard as committee this year, but I wanted to address what House Bill 316 specifically seeks to do. It would alter provisions and penalties pertaining to firearms related to offenses such as a person may not use a firearm in the commission of a crime of violence as defined in the Public Safety Act, or a felony, whether the firearm is operable at the time of the crime. It would change this offense from a misdemeanor to a felony. Number two, it would expand the definition of a crime of violence under 14101 of the criminal law article by removing the provision exempting an individual using a firearm while engaged in the distribution of a controlled dangerous substance. This has been previously referred to as the drug dealer loophole. Number three, it would require the Commissioner of Correction to provide to each incarcerated individual a reentry kit containing specified items and information prior to release from a state correctional facility, which would include but not limited to be 1 week supply of basic human needs, toiletries, ID card, contact information for reentry services, housing assistance information, mental health service assistance information, as well as information for public transportation. Number four, it would specify that a violation of a condition of probation, parole, or mandatory supervision involving the use of a firearm is not a technical violation. It states that a dealer, and number five, it would state that a dealer or other person who may not sell, rent, loan, or transfer a regulated firearm to a purchaser, leasee, borrower, or transfer if a dealer or other person has actual knowledge that that person, leasee, borrower, or transfer intends to use that regulated firearm to commit a crime or cause a harm to a recipient or other. These are just a brief summary of the bill as written, and I would respectfully submit that this is also cross-filed with Senate Bill 28, and I would request a favorable report.
Questions for the delegate? Seeing none, thank you very much. That concludes the testimony for House Bill 316.
Thank you.
Delegate Schmidt. Oh, there he is. House Bill 1445 is Delegate Schmidt's bill, and his witness with him is Grayson Wiggins, who should come on up to the table. And by the time you get there, here he is, rounding third, heading for home, is Delegate Schmidt. And the vice chair has said that you're out. All right.
What did she say? So I like it. Chair Klibinger, Vice Chair Bartlett, and the rest of the esteemed Judiciary Committee. Today we bring to you HB 1445. You like that? I'm going to get right to it. This bill would provide for personal service by a licensed private detective in situations where the landlord seeks a money judgment. Sheriff would still post or serve as set forth in statute. Currently, however, the landlord cannot opt in to hire a licensed private detective to personally serve the tenant when seeking the money judgment, in addition to seeking the right to repossess the property. This bill has three favorable testimonies provided by the Apartment and Office Building Association of Metropolitan Washington, the Maryland Realtors, and the Maryland Building Industry Association. Last week, we heard a bill in the Environment and Transportation Committee from the governor regarding renters' rights and the Stabilization Act. This was a departmental bill for the housing and community development. What that bill does is help prevent the eviction. So there's certain terms in that bill. Opponents may state that sheriffs have served this role for many years. Just last week when we heard that bill, we heard from Sheriff Sam Cogan in Baltimore City. Through 7 hours of testimony, in just 5 months of data that he's collected, they've served 37,000 128 evictions. About half of his department handles evictions. I had the pleasure of meeting with the Anne Arundel County Sheriff Everett Sesker last week, who also stated half of his department is there to serve evictions. We heard a bill this afternoon from Delegate Chisholm regarding situations where private detectives or private processors would help in situations for the sheriffs. I could go into some further detail about this, but I urge a favorable report, and I would like to have my colleague, or what do we got here, testifier, to help me with this. Sorry about that. I had good stuff here.
Good afternoon, Mr. Chair, members of the committee.
Oh, you like that?
Testifier Wiggins here on behalf of the
Testifier
Maryland Multi-Housing Association. We are in support of the bill. Contrary to some of the testimony you heard on a prior bill, we have had members experience significant delays in the rent court process as far as scheduling with the sheriff's office. Local sheriff's offices are obviously not immune from challenges with staffing shortages or funding shortages. And so my understanding is that similar policies like this have been enacted in other states. I was looking at the California court website today, and it seems to indicate that California has a policy in place for private process servers and landlord-tenant cases as well. And so for those reasons, us too. Thank you, Mr. Chair.
Questions for the panel? Okay, seeing none, thank you very much. There is a person to testify in opposition, but he's not on virtually. It's Matt Hill from the Public Justice Center. Not here. All right. Well, then that concludes the testimony on House Bill 1445. Delegate Roberson went upstairs to HGO for some inexplicable reason. So now we have Delegate Conaway to present House Bill 1448. Megan McDermott, are you also here? I don't see anybody else here. You have a person signed up to testify, Delegate Conaway, but I don't see them. So it's just you.
Thank you, Mr. Chairman.
All right.
Thank you, committee. I'm Delegate Frank Conaway Jr. here to present House Bill 1448, Maryland Vehicle Administration Driving Records Expungement. Basically, what this bill does, it says if you had a civil case and your criminal or your criminal case and your criminal record was expunged, that MVA should do automatic expungement of that record also. And from their information, it looks like they can do this with the funding that they already have, so it's no additional funding. And it looks like I had a few favorables and two information-only testimonies that were entered. And I'll be glad to answer any questions if I can.
Just out of curiosity, Megan McDermott? Yes. Come on up to the table. I called you, that's fine. See, there you did have somebody to testify with you. All right.
How you doing? Thank you.
Ms. McDermott, please.
Okay.
Go ahead.
Good afternoon, Chair, members of the committee. Thank you for the opportunity to testify. My name is Megan McDermott. I'm a chief attorney at Maryland Legal Aid. We urge a favorable report on House Bill 1488. House Bill 1488 will help limit the impact of collateral consequences resulting from criminal records. The bill gives the expungement statute teeth by requiring that the Motor Vehicle Administration expunge driving records that are associated with expunged criminal cases. Legal Aid completes thousands of record expungements each year, and clients regularly express concerns about how their expungements impact their driver's licenses. We use the term collateral consequences a lot when we talk about expungements, and what we mean by that is real life challenges. A bad driving record has financial impacts. Points on a license can increase car insurance payments. Driving records can also affect people's ability to work, either because they need a license to commute to their job or because their job itself requires a driver's license in good standing. For example, many legal aid clients work for rideshare companies or have commercial driver's licenses. An active driver's license is essential for many other aspects of daily life. So people can take their kids to school, so they can go to the grocery store and run other errands. This is especially true in areas without reliable public transport. The traffic regulations already require the MVA to expunge certain types of records. Adding a provision requiring automatic expungement of driving records related to expunged court and police records ensures that someone who receives a criminal record expungement receives a full expungement. Thank you again for your time, and Maryland Legal Aid urges a favorable report on House Bill 1488.
Are there questions? Delegate Kaufman.
Yes, thank you. Of course, I had to ask my friend a question. Delegate Conaway, or your witness from Legal Aid, have you had a chance to review MVA's letter of information where they say your legislation could change the way that they calculate points and determine appropriate increasing sanctions for drivers? If not, I can print out the thing for you and give bring it to your office another day. But I was just wondering if you had any response to their letter of information.
Yeah, you're talking about the MDOT letter?
Yes.
Yes, I saw that. And well, I thought to myself, knowing what I know, that if they don't expunge something that's on your record, then you're subject to get calculated with more points than you actually should have. So therefore, why not get it off your record immediately? And therefore you start to save some of your money and your points go down, and you might even be able to get with a better insurance company. I don't want to say who, but.
Ma'am, do you have any comment?
I haven't had the opportunity to read it, but I would say that is sort of the point, that we want people to be able to have lower insurance payments. And if we're saying in Maryland that we're expunging criminal records and they no longer exist, then they shouldn't have an impact on people's driver's licenses.
How long is something on someone's driver's record? How long are the points on the driver's record?
It depends. I think it depends on the severity of the crime.
Sure.
If they're a recidivist. So I think it can be anywhere from a year to 5 years. It could be longer as well. That's just what I've seen with our clients.
And what kind of traffic cases would you seek to expunge?
Well, so
you're not seeking, are you seeking to expunge DUIs?
No, we
Right,
can't
so they're not,
expunge-
you can't expunge a DUI, so that's there. I'm trying to think of what crimes
So
you would be
16.3
seeking to, driving suspended, is that what?
Yeah, 16303 was added
Right.
to the statute not long ago, and that's the main one, driving on a suspended.
And what's the suspended driver's license? Yeah, so what I'd have to look it up in the expungement section, but I was trying to think of how long it takes before you can expunge and whether it's just the regular.
It's a 5-year wait. It's the same as other misdemeanors, so it's a 5-year wait after the completion of sentence.
So it wouldn't really impact the points because the points would be going away anyway at that point because it would be 5 years by the time we got there, right? Yes.
If I may, Mr. Chairman,
Sure.
if you were to challenge your ticket and go to court and win, and then you would apply for your ticket to be expunged or your charge to be expunged, it wouldn't automatically be expunged with the MVA. It's be separate.
No, I get that. I'm just trying to think of the case where you got your driving suspended conviction expunged on the criminal, but not MVA side. It would take such a period of time that by the time it got to MVA, the points would have fallen off your record anyway.
Not if it's a 5-year charge, because you probably could go
Yeah,
to court
okay.
within 6 months or something like that.
Okay.
And have it resolved.
I think
Okay,
it's
but-
also if someone receives a second offense that we're hoping
Right.
that the first offense would be expunged, so then they wouldn't
Right.
accrue additional points.
Right. All right. I've asked a sufficient number of questions on this, perhaps to allow someone to get back. Delegate Tomlinson.
Thank you, Mr. Chair. I was hoping you would keep going because I was
why?
I was hoping you were going to keep going because I was trying to look something up. No, and you asked mostly what I was going to ask. Yeah, because some of your, like a speeding ticket over several years eventually does, I don't know what the legal term is, but does like drop off.
Yeah.
And in regards to your insurance, not really, to it not affecting your insurance. And then also, it's not an expungement, but like I'm literally on case search is what I was trying to look up myself. Like speeding tickets do eventually come off of there on their own.
If I may, as I understand it in writing the bill, I understand that you have two different records at MVA. You have a general record and then you have your full history record. Your full history record doesn't necessarily drop off, so to speak, and your current record can drop off. But as I said, if you go to court and something is thrown out in court, then how do you challenge it in the MVA to say, I've been exonerated of this, so can you remove it from my record today?
And you were thank you, Mr. Chair. You brought up driving on a suspended license, so that is something you can get expunged. But you're saying with this bill, you want it to be an automatic expungement. Is that correct?
No, just automated in the traffic system. So if it's expunged criminally, then it's also expunged in the
Okay.
traffic system.
Gotcha.
Yeah.
Cool. Thanks.
If I could add one more thing.
Sure.
You might want to understand that some people who have these child support arrearages might have suspended licenses and not know that their license is suspended until they get pulled over. And then they find out. So then they try to straighten out the situation, but they have this bad mark on them for X number of years that they're trying to take care of. Oh, it did?
All right. See no further questions. Thank you very much.
Thank you, committee. I asked you for a
you.
favor.
That was House Bill 1448. Now we're on House Bill 1406. Delegate Roberson, who unfortunately lost his only person who was going to testify virtually because they're ill. So Delegate Roberson for 1406.
Thank you, Mr. Chair, and I think it might be for the best. So I'm a panel of one. Good afternoon, Mr. Chair, Madam Vice Chair, and the hardest working committee in Annapolis, Judiciary Committee. I'm Delegate Ken Roberson from District 25, and I'm here to speak in support of HB 1406, the drunk and drug driving points assessment legislation. This legislation seeks to fix an error in the Maryland Transportation Article, Section 21-902. In 2019, just for background information, legislation changed the penalties for DWIs and DUIs by increasing those penalties, but not addressing the points drivers are assessed. And so the MVA became aware of that. And although the penalties have increased, the point system was not included in the original legislation in 2019. So currently the MVA has really not the authority. They can assess points between 8 and 12 points, but they believe that they do not have the authority to actually determine what that points assessment should be. Therefore, I am here asking that we pass HB 1406 to assess, which is repeat DUI and DWI offenders with the 12-point assessment, which is the maximum points that are allowable under the current system. And I would note that the Maryland States Attorneys Association has also provided written testimony that goes into greater detail and background on this bill, as well as our fiscal note kind of gives a background history. I will also note that there is no opposition to this bill and the MVA is also supportive. Therefore, I request a favorable report for this bill and I'm available for questions, but also request that none are raised. Thank you so much, Mr. Chair. Happy AK Day, Madam Vice Chair.
Well, guy can dream. Are there any questions for the delegate? Seems like a really well thought out bill. I'm not sure where you got it from. Delegate Conway, though.
Thank you, Mr. Chairman. Thank you, Delegate, for bringing the bill. Do you know what the current amount of points is for for the two violations of 44 and 45?
I didn't hear the last part. For
Page 2, line 1, line 2, number 44, number 45. It says 12 points, 12 points. Is that current? Or that's
page
an
2,
increase?
line 1 and line 2. No, that is the new addition.
Right,
There is no designation in legislation now for points. So this bill would designate 12 points.
Right. And at how many points does when you accumulate, how many points does your license become suspended?
12.
So this will be an automatic suspension of license, right?
Correct.
Right. Okay. Thank you.
But isn't it so, Delegate, that it would be an automatic suspension of license for a subsequent DUI conviction?
Correct.
So the first DUI could get you 12 points to start with.
That's correct.
So the second DUI should get you 12 points then as well, arguably.
Yes, sir, Mr. Chair. I'll also note that for this section, though, it is after your second/third attempt. So it goes beyond that. So this legislation is dealing with those third, fourth, fifth offenses. Thank you.
Delegate Crutchfield has a question.
Just a tiny one. Thank you for bringing this bill. Appreciate, isn't it so, you cleaning up this legislation that I actually sponsored the very first time. So appreciate that.
And I appreciate you for bringing the bill and allowing me to tag team in on this.
Is it also possible that this bill was done in Delegate Crutchfield's first year?
Wonderful.
And so full circle, sort of. All right, let's stop being nostalgic now. Any other questions for this delegate? Seeing none, thank you very much. That concludes the testimony on House Bill 1406. That concludes the testimony today. Tomorrow, we have a grand total of 13 witnesses tomorrow. There will be a voting session tomorrow after the after bill hearings. A list of bills will be soon posted online. And I would say to members of the committee that it is likely that not only will the civil committee be meeting on Friday, but also there is a likely second voting session on Friday afternoon as well. Oh, civil was postponed to Tuesday, so never mind the civil part. So we will have most likely a voting session immediately after session.